tablet and I downloaded all those educational games. We didn't have them enough to teach them enough.
Stay home.
Yellow.
We're here to observe. With all the students.
Yes,
Well, we know if the Creole interpreter is joining us.
yes, the Creole interpreter has been requested and he will be appearing.
Thank you so much.
You're welcome.
For all those that are attending remotely, this is Judge Kaler. I have muted everybody's device. Please keep those devices muted. If there's a private attorney, I will indicate when I'm ready for those people to be called and you can unmute your device. If it's anybody else here to observe, please keep your devices muted. If you fail to do so, I will remove you from this court proceeding and you will not be allowed back in. Thank you. All right, Central, can you turn your camera on, please? Central, please turn your camera on. Central, are you fully loaded?
Yes, ma'am.
So it looks like I think we have the real interpreter on as well. Okay. And Ms. Fahey,
Yes, Your Honor.
all right, Ms. Fahey, have you been sworn in today?
No, I don't remember.
You swear or affirm to accurately translate from English to Spanish and Spanish to English?
I do swear, Your Honor, for the record, Sandra Fejo, Court Interpreter's Office.
Mr. Moise, same thing. Do you swear or affirm to accurately translate from Creole to English and English to Creole?
I do. For the record, Alex Moy, certified court interpreter.
Thank you. And Mr. Moise, I don't know how you want to do this. Normally I do the colloquy. I know Ms. Fejo has the whole colloquy and she does it. Do you want me to piecemeal it for you or how do you want to do that?
I can repeat after Miss Sandra Fejo.
Okay, all right, thank you so much.
Sure.
All right, if everybody could please stand to be sworn in.
Est-ce que tout le monde est capable de lever pour être capable de faire sermenté?
Todas las personas, por favor, pónganse de pie y prepárense para ser juramentados.
South County, I need you unmuted. There you go. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? If so, say I do.
I do.
Est-ce que nous sermentez pour nous dire la vérité, toute la vérité selon...
Hey, what up, everybody? How's everybody doing today?
¿Jura usted decir la verdad? Y de ser así, diga que sí.
Hopefully, everybody's doing
Yes.
good
Okay, you can be
today.
seated. Mr. Odom, you didn't raise your right, hand, nor did you say anything. So let's try that again. Sir, I'm staring at you. Don't lie to me. Raise your
What?
right hand.
Lie to me?
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? Excuse me?
I said, aye, ma'am.
Thank you.
Uh,
Have a seat.
Damn. Judge is already
Okay,
tripping.
this is your first appearance hearing. The first appearance hearing has 4 purposes and 4 purposes only. First, I will advise you of the charges that have been filed against you.
Ça, c'est la première fois qu'on paraît devant le juge. Gain raison.
What up, Vanessa? What up, Shannon?
C'est premièrement
I'm
pour
feeling
capable
pretty good, thank you.
déterminer si gain bon genre raison pour rejoindre dans le tribunal là.
Oui.
Second, I
Oui,
will
oui.
ask if you have an attorney representing you.
Deuxièmement, je vais demander est-ce que vous avez un avocat qui représente vous?
If you've hired counsel and they are present, they will speak on your behalf.
Si vous avez pris un avocat et que présent, il a parlé pour vous.
If your attorney is not present, you will have the option of proceeding forward with your hearing today or postponing it until tomorrow.
Si l'avocat n'est pas présent, vous avez l'opportunité soit que pour continuer jeudi à la pour contour, ou bien vous êtes capable de demander pour renvoyer pour demain.
If you postpone the hearing, it is your responsibility to contact your attorney to let them know that you have court.
Si vous demandez pour renvoyer pour demain, c'est responsabilité ou pour capable relayer avocat ou pour dire que vous avez un tribunal demain.
Nobody else will do that for you.
Personne ne peut faire ça pour vous.
If you wish to move forward without your attorney present, we can do that.
Si vous avez poursuivre ou continuer sans qu'on ait un avocat qui représente vous, nous sommes capables de faire ça.
If you do not have an attorney, I will ask if you can afford one. If so, we will make note of that and move on.
Si que vous pas capable de prendre pour avocat ou, moi suis capable de faire, assurez-moi que vous capable de prendre une.
If not, and you qualify, I can provisionally appoint the Office of the Public Defender to represent you pending you filling out an application.
Polk County, yup. Daisy?
Si
Hey,
que
what
vous
up, Chad?
qualifiez, je suis capable d'avoir un avocat de la défense publique qui pourra représenter provisoirement.
What up, Vanessa? What up, Lexi? Hello, Governor.
You have a right to have your attorney present during and before any questioning.
Vous avez tout droit pour un avocat qui est présent, soit que pendant la pose aux questions ou bien avant de poser aux questions.
Third, if there are any challenges to probable cause, I will address those.
Et troisièmement, est-ce qu'il y a aucune raison, est-ce qu'il y a aucune...
Shane, it went well, yep.
Finally, I
What
will
up, Trish?
review your bonds and or other release conditions with you to
Ah,
determine
wow.
if any changes are necessary.
Finalement, on va réviser bon, et s'il n'y a aucune nécessité pour nous changer bon, nous sommes capables de réviser ça.
What up, my lights, Peachy?
Be aware that if this court places you on pretrial release today, regardless of whether it's straight pretrial release or a condition of your bond, the conditions announced in court go into effect immediately.
supposons que le tribunal, la juge là, mettez dans liberté provisoire ou conditionnelle, liberté conditionnelle et toute condition pour liberté conditionnelle là, il a commencé immédiatement jeudi.
That means even while you're in custody.
Ça veut dire que
Damn, that one has the walker. I got one of those.
Throughout this entire process, you have a constitutional right to remain silent.
Pendant toute procédure ça, vous avez tout droit constitutionnel pour être en silence pour pas dire rien.
If you choose not to remain silent, anything you say can be used against you.
How is everybody doing today? Jeanette, yeah, they are.
Tout bagay ou di, ou capable kembe yo contre ou même.
7 days. They give me a
Everything that
7
is being
day.
said where I am located as well as where you are located is being recorded.
Hey, what up, Tommy?
Que
Gracias.
ce soit à côté moi-même, moi,
That's Creole.
que ce soit à côté où
Oui,
tout
oui.
bagay que n'a dit a enregistré.
What up,
There's
Matthew?
an assistant state attorney present listening to everything that is being said, so do not say anything about the crime itself.
Bon avocat l'État qui campait là, qui attendait tout
What
ça
up, boy?
qu'on a dit.
Adam?
Moi, m'a recommandé
Russell?
pas dire rien du tout.
Please keep these rights in mind as we go through the process.
Quel est le droit constitutionnel ça yo dans l'esprit ou pendant que la poursuivre.
Please step forward when your name is called.
Le cité non, s'il vous plaît, approchez.
You, Ms. Viejo.
Thank you. Discurso de primera audiencia de primera comparecencia. Estamos aquí hoy para una audiencia de primera comparecencia.
Mississippi, thank you.
Una audiencia de
Marie.
primera comparecencia tiene únicamente 4
Bells.
propósitos. Primero, le informaré cuáles son los cargos interpuestos contra usted. Segundo, le preguntaré si ya tiene un abogado que le represente. Si usted ya ha contratado su abogado privado o él o ella está presente con usted en esta audiencia, hablará por usted. Si su abogado no está presente en esta
Spanish
audiencia,
and Creole,
usted
yep.
tiene la
What up,
usted
Eva?
tiene la opción de proceder hoy con su audiencia o de
Proceder.
posponerla para mañana. Si usted decide posponer la audiencia para mañana, será su responsabilidad comunicarse con su abogado y
Voy a
hacerle
poner-
saber que usted tendrá una audiencia. Nadie podrá hacer eso por usted. Si usted desea proceder sin su abogado presente, puede hacerlo. Si usted no tiene un abogado, yo le preguntaré si tiene los medios económicos para contratar uno. Si es así, haremos unas preguntas. Sépase
What up,
que,
G? JG.
que estaremos haciendo esta pregunta. Si desea que su abogado esté presente, puede hacerlo. Okay. Si usted no tiene los medios económicos suficientes, yo puedo nombrarle a la oficina de abogados de oficio para que le represente. Usted está esperando que usted llene una solicitud. Tiene el derecho a que un abogado esté con ustedes antes y durante cualquier interrogatorio. Tercero, yo me ocuparé
What up, Brent?
de resolver cualquier
What up,
acusación
Christopher?
presentada con respecto a motivo probable de su delito. Finalmente, revisaré con usted las fianzas y otras condiciones de la libertad que hayan sido impuestas hoy, sin importar si es una libertad condicional,
Hey,
sin
thank you,
pago de
Marlies.
fianza o las condiciones de fianza. Las condiciones que el juez anuncie hoy entran en efecto
Or should I say, sticky
inmediatamente, aun
situation?
cuando usted se encuentre
I
bajo
feel- I'm feeling a
custodia.
lot better.
Durante todo este proceso, usted tiene el derecho constitucional de guardar silencio. Si usted elige decir algo, cualquier cosa que usted diga puede ser usada en su contra. Todo lo que usted diga donde yo me encuentro aquí, como donde ustedes están, está siendo grabado. En la sala del juzgado se encuentra presente conmigo un fiscal asistente del Estado, escuchando todo lo que se dice.
What up, Simona?
De manera que por favor no diga nada sobre el delito en sí. Sírvase de tener estos derechos en mente a medida que avancemos con el proceso. Por favor, cuando llame su nombre, pase adelante.
This is going to be Polk County, Florida.
The Creole case first. Alfred Dorville.
Come on down.
Dorville, approchez, s'il vous plaît.
Oui, oui.
Sir, you're here on a charge of battery on law enforcement officer.
Monsieur Oula, premièrement, parce qu'il est accusé au côté agressé un officier de police.
Resisting officer with violence and resisting officer without violence.
Et ou tap résisté au officier sans violence, et ou tap résisté au officier.
That's
avec
right, my
violence.
life.
Pas dit rien, monsieur.
Do you have an attorney?
Talking in Spanish.
Est-ce que vous avez un avocat, monsieur?
Oui, mge avocat, mais li pa la jodi a.
Yes, I have an attorney, but the attorney is not here today.
Then you don't got an
Do you have an
attorney.
attorney on these new charges?
Donc, une accusation nouveau, ça yo. Est-ce que vous avez un avocat?
Oui, gen avocat.
Yes, I do have an attorney.
Okay.
A little bit of Spanish sprinkled
I
in
have previously
with Creole.
reviewed the affidavit. I do find probable cause.
Moi, te révisé affidavit, yo, moi, jeune que gen bon gens raison pour aucun bon.
You have a bond of 5,000 on the battery on law enforcement.
Ou gen un bon de $5,000 du fait que
Does anybody in here speak Creole?
5,000
understand what the
resisting
translator is
officer
saying?
with violence.
$5,000 parce que tu as résisté officier avec violence.
1,000 on resisting officer without violence.
Love Buck, thank you.
$1,000 parce que tu as résisté officier sans
$1,000.
violence.
All right, thank you.
Merci, monsieur.
Merci. Merci.
That's it for the Creole. Thank you very much,
Thank
Mr.
you, Your
Rose.
Honor. Yes, thank you, Your Honor. Have a good day.
We're going to do the Spanish now.
Español.
Vicente Belen Quesada.
Come on down, Vicente.
Belén Posada.
Come on down, Vicente. What
Sir,
you
you're
do?
here on a charge of no valid driver's license.
Señor, compárase aquí, se le acusa de no tener una licencia válida de conductor.
Have an attorney?
No driver
¿Tiene un
license. How dare he?
No,
No.
You like one?
¿Le desea que se le nombre uno?
no, lo que pasa es que en la computadora me dijeron que yo podía pagar el bonus que me dijeron, 250, y que me iban a mandar a una corte.
No, what's going on is I was told that they found on the computer that if I just pay the bond that's going to be $250, they were going to send me to court.
That's not what I asked. I just want to know if you wanted an attorney.
Huh?
Eso no fue lo que yo le pregunté. Yo quiero saber si usted quiere que un abogado lo represente.
Yes or no? Sí o no?
No.
No, yo tengo, no.
I have previously reviewed the affidavit. I do find probable cause.
He examinado anteriormente la declaración jurada por escrito. Determiné que se establecieron motivos fundados para
You have a bond
justificar
of
los cargos.
You have a bond of $500.
Se le fija una fianza en la cantidad de $500.
Thank
But
you,
they
sir.
told me 250.
Señor, gracias.
Enrique Mendoza.
Enrique Mendoza.
I couldn't imagine being in jail.
Senator Smith, Public Defender's Office. I do have a stipulation with the state regarding one of the charges.
Su señoría, Sandra Speed, representando a la Oficina de Abogados de Oficio. Tengo una
What up,
estipulación
Amber?
con la Fiscalía en cuanto a algunos de los cargos.
That there is no probable cause and he should be released on his own recognizance on the possession of an open container charge.
Open container.
De que no se han establecido motivos fundados y el
What up,
debe ser
Helen?
puesto en libertad bajo palabra en cuanto a tenencia de tener embriagantes abiertas.
State you're in agreement.
No
¿Usted
sé.
está de acuerdo?
Yes, Your Honor. ¿Cómo? No entendí.
Sí,
No
su
Nintendo.
señoría. What are you talking about? I didn't understand.
I'm not talking to you.
No estoy hablando con usted.
I'm not talking
Just
with
wait a
you.
minute.
Wait a
Pero un
minute.
momento.
Okay, so sir, what you're here on today is a charge of no valid driver's license and possession of an open container.
Oh, this was DUI in
Señor,
it?
comparece aquí hoy, se le acusa
Hey,
de
Sancho,
no tener
gracias.
una licencia válida y tenencia de bebidas embriagantes abiertas.
You have an attorney, sir?
Señor,
No.
¿tiene un abogado que lo represente?
No.
No.
Do you like an attorney?
¿Le gustaría que yo le nombrara un abogado?
No. No sé.
No creo.
I don't
O sea, I
think
don't think so.
Okay, you change your mind at your next court date, let the judge know.
Muy bien, si cambia de opinión la próxima vez que comparezca ante el tribunal, déjeselo saber al juez.
I'm in agreement with the state and defense. I find no probable cause on the possession of an open container.
Concuerdo con el Estado y la defensa, determiné
That's
que
the
no
first.
se establecieron motivos fundados en cuanto al cargo de tenencia de recipientes abiertos.
You'll be ROR'd on that charge.
En cuanto a ese cargo, se pone en libertad bajo palabra.
I find probable cause for the M2 version of no valid driver's license.
Sí determiné motivos fundados para la versión M2 en que de no tener una licencia válida de conductor.
You have a bond of $500.
Y le fija una fianza de $500, señor.
All right, thank you.
Gracias.
Eric Morales Reyes.
I couldn't imagine
Eric
being in jail
Morales
for an open
Reyes.
container. That's wild.
Sir, you're here on a charge of domestic violence battery.
Agua.
Señor, comparece aquí acusado de violencia intrafamiliar con lesiones.
Do you have an attorney?
¿Tiene un abogado?
No.
No.
Like one?
¿Le gustaría que le nombrara uno?
No.
No.
Now, what's up with these dudes not getting a lawyer?
Si después usted desea que se le nombre un abogado de oficio, déjeselo saber al juez.
Yeehaw, thank you.
Previously
Bella.
reviewed the affidavit. I do find probable cause.
Examiné anteriormente la declaración jurada por escrito, determiné que se establecieron motivos fundados.
Bond of $5,000.
Le fijo la fianza en la cantidad de $500.
If you're able to bond out, you will be placed on pretrial release.
De salir bajo fianza se le impondrá unas
What up, Jerome?
condiciones previa, una puesta en libertad con condiciones previas al juicio.
Must report the day of or morning after your release and report every Tuesday.
Deberá reportarse la mañana después de su puesta en libertad y deberá reportarse después de cada semana,
In
los
addition,
martes.
to the standard conditions of pretrial release,
Además de las condiciones que normalmente se impone como en cuanto a la libertad previa al juicio,
you're not to use, possess, or carry any firearms, guns, weapons, ammunition, or knives.
también se le prohíbe el uso, portar armas de fuego, pistolas, armas, munición alguna o armas blancas.
You are to have no contact with the victim directly or indirectly.
Se le prohíbe que tenga contacto o interacción alguna con la víctima directa o indirectamente,
Person in writing by telephone, pager, fax.
ya sea por persona, en persona, por escrito, por teléfono, por medio
What up,
de
Lisa?
busca personas o por vía fax,
Texting, email, social media, or through third persons.
por medio de mensajes de textos, redes sociales, correos electrónicos o por medio de terceras personas.
You must stay 500 feet from the victim, victim's home, vehicle, place of employment.
500 feet. I knew it. I knew it was 500 feet,
En
not
todo
foot.
momento deberá mantenerse a no menos de 500 pies de retirado de la víctima, su casa, su vehículo, lugar de empleo y escuela.
May return to the residence one time within 48 hours of your release from custody.
Después de su puesta en libertad, se le permite regresar a la residencia en
What
una
up,
sola
Sunsets?
ocasión.
Accompanied by law enforcement.
What up, Hector?
Hey,
thank you, Hector. Highly appreciate you.
Horas, siempre y cuando esté acompañado por un agente del orden público para retirar sus efectos personales.
Thank you, sir.
Gracias, señor.
Thomas Noyola Alvarez.
Tomás Noyola Álvarez.
You're here on a charge of resisting officer without violence.
Comparece acusado de resistir la autoridad sin violencia.
You have,
Sí.
Yes.
you have an attorney?
¿Tiene un abogado?
No.
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 Findings, immunities.
I'm sorry, Your Honor, did the court speak?
I don't think I know anybody that could afford a lawyer.
Correcting something the clerk had on their documents. If there's any on previous ones that needs to be taken off. Would you like an attorney, sir?
Señor, ¿le gustaría que yo le nombrara un abogado de oficio?
Sí.
No.
What?
No.
You moron?
You change your mind at a later date, let the judge know.
Si después cambia de opinión, déjeselo saber al juez.
I have previously reviewed the affidavit. I do find probable cause for the M1 version.
Examiné anteriormente la declaración jurada por escrito, determiné que se establecieron motivos fundados
Hey,
en
Raven,
cuanto a la
thank you.
versión del M1.
You have a bond of $1,000, sir.
Se le fija una fianza en la cantidad de $1,000, señor.
Thank you.
I think they're all copying
Gracias.
each other's answers.
Javier Perez.
They're cheating on the
Javier
test,
Perez.
if you will. The only thing is not a
You're here on
test.
charge of no valid driver's license and
It's the
resisting
their
officer
life.
without violence.
Señor, se le acusa de no tener una licencia válida de conductor y resistir la autoridad sin violencia.
You have an attorney?
¿Tiene un
No.
abogado?
No.
No.
Like one?
¿Le gustaría uno?
No.
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 Another moron.
Change your mind at a later time, let the judge know.
Si después cambia de opinión, déjeselo saber al juez.
I have previously reviewed the affidavit. I do find probable cause for the M2 and M1 version.
Anteriormente examiné la declaración jurada por escrito y determiné que se establecieron motivos fundados para justificar los cargos M1 y M2.
You have a bond of $500 on the no valid driver's license and $1,000 on the resisting officer without violence.
Se le fija la fianza de $500 por no tener una licencia válida de conductor
Thank you,
y
Lisa.
$1,000 en cuanto a resistir la autoridad sin violencia.
Thank you, sir.
Gracias, señor.
Felicito Sanchez Garcia.
Melacito Sánchez García.
Sir, you're here on a charge of resisting officer without violence.
Señor, comparece a resistir la autoridad sin violencia.
You have an attorney?
¿Tiene un abogado?
What up, señorita?
Ya tengo una.
Ajá, bueno.
He has one.
Okay. You want to proceed today without them, or do you want to contact them and come back tomorrow?
Mañana.
¿Quiere proceder hoy sin su abogado o desea ponerse en comunicación con ellos y regresar mañana?
He's gonna go on.
Mañana, no sé si se encuentre presente él ahí ahorita.
What up, yo mama?
Me dijo que iba a estar ahí.
Oh,
well,
what?
I don't know if he's present here today. He said he was going to be.
Well, there's nobody in the courtroom and nobody has spoken up when I called your name.
No hay nadie aquí en la sala del juzgado y nadie llamó o habló cuando yo llamé su nombre.
Okay.
Okay.
Which would you like to do, sir?
¿Cómo desea proceder, señor?
Empty. We're in the Spanish cases right now.
I'll call my lawyer tomorrow.
What up,
Do you want to
Erica?
proceed today, or do you want to be brought back tomorrow?
¿Quiere proceder hoy o desea que regresar mañana?
No, hoy.
Today.
I have previously reviewed the affidavit. I do find probable cause for the M1 version.
What up, Laura?
Anteriormente revisé la declaración jurada por escrito, determiné que se establecieron motivos fundados para justificar los cargos de categoría de M1.
You have a bond of $1,000.
Se le fija una fianza en la cantidad de $1,000.
Thank you, sir.
Señor, gracias.
Jose Sepulveda Rivera,
Thank you, Kayla. What up,
José
Austin?
Sepúlveda Rivera.
Toyo.
you're here on a charge of prohibition, dangerous use of a public right-of-way.
Señor, comparece aquí.
Come
donde
again?
Se le prohíbe uso público, el derecho al uso público en calidad de peligrosidad.
Do you have an attorney?
¿Tiene un abogado?
No.
No.
Would you like one?
¿Le desea que le nombre uno?
Sí.
Yes.
Are you currently employed?
¿Trabaja actualmente?
No.
No.
I'm going to appoint an attorney for you.
What up, boy, mama?
Le voy a nombrar un abogado para que los represente.
I have previously reviewed the affidavit. I do find probable cause.
Sunshine.
Examiné anteriormente la declaración jurada por escrito, determiné que se establecieron motivos fundados para justificar los cargos
And a bond of $1,000.
y le fijo la fianza en la cantidad de $1,000.
All right, thank you.
Gracias.
A ti.
Clarification, he would be a court-appointed attorney, not a public defender.
Correct.
Thank you.
What up, Chacha?
Y para estar claro, esto sería un abogado nombrado por el tribunal, pero no un abogado público de oficio. Así es.
Ms. Bayham. I think that's all we have.
Thank
All
you.
right, all
The
right. So we're going to go ahead and
interpreter is
commence with the
Thank you.
English speakers only, if you
Do
will.
I have any private attorneys online?
Get ready. If you guys are single, ready to mingle, you might find love here,
afternoon, Your Honor, Catherine Aranda.
or probably one of the worst
Sorry?
mistakes of your life.
I am here for Jeremy Ford.
Jeremy
is this?
Ford.
This is Catherine Aranda.
Okay, Jeremy Ford.
Jeremy Ford, come on down.
Perfect. Mr. Ford, you're here on a violation of probation for your prior charge of scheme to defraud. I have previously reviewed the warrant. Do you wish to be heard at this time?
Yes.
Ms. Aranda?
No, Your Honor, thank you.
I
I
have
just
previously reviewed the warrant. There is probable cause, and at this time you are being held no bond, sir, okay?
Yes, ma'am.
Thank you.
that we ain't going nowhere
Have a
anytime
good day,
soon.
Your Honor.
Love on the spectrum. That's right.
Any other private attorneys on the line? Mr.
Right here,
Odom?
you could get it all right
Mr.
here.
Odom?
You could
I'll
get
speak
it
out
all.
on this one, Judge.
Hey, thank you guys for you guys that are tapping. Highly appreciate you guys. Always remember, tapping is free. Doesn't cost you anything.
Aggravated battery causing bodily harm. Do you have an attorney?
No, ma'am.
Would you like one?
I don't want no money.
Well, that's okay. We can appoint a public defender. Do you want me to do that?
Yeah.
Okay, I'm going to appoint the public defender to represent you. I have is the charge going to remain the same, state?
At this time, yes, ma'am. Second degree felony aggravated battery cause great bodily harm.
Okay.
What I understand that may change in the future, but at this time, it is the F2.
Okay. I have previously reviewed the affidavit. I do find that there's probable cause. State, you wish to be heard.
Yes, Your Honor, thank you. Under 907-041, 5A, I believe it's 3, aggravated battery is an enumerated dangerous offense. This is an F2. After learning from additional details about the crime alleged, this is a May file under pretrial detention. Learning more about the surrounding circumstances, I would like to file a motion for pretrial detention. I do not have copies for appointed counsel because I wrote it in court, because I did not want to delay this until tomorrow for written motion. So I am asking to provide the court a motion for pretrial detention. May I approach?
Approach.
I would ask the court to review that motion, and if the court finds it facially sufficient, that the accused be held no bond pending a hearing on that motion, it should be set for next Monday at 1 o'clock on the A2 docket. And I will provide a copy to appointed counsel promptly.
The next Monday.
Yeah, yes, ma'am.
Yes, this,
Defense, do you wish to review this real quickly?
I apologize, Judge. I should have shown it to
Yeah,
defense counsel.
that would be good, Your Honor.
can I ask a question? I already probably know the answer. I guess that this stops my release tomorrow for my probation, 18 months, then.
Yeah.
Another case here, I just got done out of. Just stay in here.
This guy. Some people just never learn, do they?
The standard motion. Thank you, Your Honor.
Defense has reviewed the motion. I have reviewed the motion. I do find that it's legally and facially sufficient. So at this time, Mr. Odom, you are going to be held no bond, but you will have a hearing in front of a judge on, what day was that again?
Should be next Monday, which is going to be April 13th.
Okay, so April 13th, and that judge will determine if they're going to give you a bond, right?
And who's going to tell my other judge about my other charge I just got out of? They said they about to release me, and I can't be released now.
That is correct.
Yeah.
Yeehaw! Thank you, Just
All
B.
right, thank you. All right, Tyler Adams? Mr. Adams, you're here on a charge of domestic violence battery on a pregnant victim.
Oh,
Attorney?
what?
I do have an attorney, yes.
Who's your attorney, sir?
Christine Check Thornhill.
Do you wish to proceed today without your attorney, or do you want to try to contact them and come back tomorrow?
Who does
we can
that?
proceed.
Okay. I have previously reviewed the affidavit. I do find probable cause. You have a bond of $15,000. If you are able to bond out, you will be placed on pretrial release. You must report the day of or morning after your release and report every Tuesday. In addition to the standard conditions of pretrial release, you are not to use, possess, or carry any firearms, guns, weapons, ammunition, or knives. You're to have no contact with the victim directly or indirectly, in person, in writing, by telephone, pager, fax, text, email, social media, or through third person. You
Polk
must be
County.
500 feet away from the victim, victim's home, vehicle, place of employment, and or school at all times. You may return to the residence one time within 48 hours of your release from custody, accompanied by law enforcement to get your personal belongings. All right, thank you, sir.
Thank you. This one.
George Allen?
That's wild. Hey,
George Allen?
he must be one of those people. He must be one of those
Is this the
people
first
or
day?
individuals talking about her face was
Do you wish
pregnant.
to proceed in his absence?
That's fine.
All
A
right,
real
state
piece
your
of
name
work,
and
if you
agreement
will.
with that.
Yes, Your Honor.
Okay. So Mr. Allen is here on a charge, 2 counts of petty theft. I am going to provisionally appoint the public defender to represent him in these matters. I have reviewed the affidavit. I do find probable
What up,
cause, and he
Jefes?
has a bond of 1,000 per count. Can somebody please let Mr. Allen know that he has bonds?
Yes, Your Honor.
Thank you. Christopher Brito?
Sanderson Flight Defender's Office, Your Honor. I do have a stipulation with the state regarding one of the 2 criminal mischief charges, that on one of those charges, that there's probable cause for a secondary misdemeanor as opposed to the first degree misdemeanor.
Open your eyes.
Your Honor, it appears from the description of the damage in the second count that it probably meets the threshold. However, considering the other charges attached to this case, state's not going to request time to perfect, so we'll stipulate for today's purposes.
Okay, so sir, you're here on a charge of burglary of an unoccupied structure.
Hold on 1 second. Hold on 1 second. I didn't
Oh,
steal
yeah.
nothing.
Oh,
Or
that's
like-
I didn't steal
right.
anything, Your Honor. I just want to make that real clear. Continue.
2 counts of criminal mischief.
Okay.
Have an attorney?
I do not have an attorney. I'm supposed to have a public defender. You can contact my Saeed and everybody in Hillsborough County. I did not steal
Would you
anything.
like an attorney?
Yes, I would.
Okay, are you currently employed?
No, unemployed. I worked at Luma Staffing. Tried coming over here to Polk County.
I'm going to appoint the public defender to represent you. I have previously reviewed the affidavit. I am in agreement with state and defense as to one count of criminal mischief. It will be probable cause to the lesser. I do find probable cause for the remaining charges. You have a bond of $15,000 on the burglary, $5,000
still
on the grand
nothing.
theft, $5,000 on the burglary of an occupied structure, $5,000 on the attempted burglary of a conveyance, $1,000 on criminal mischief, and $500 on the other criminal mischief.
Okay.
All right, thank you, sir.
The lie detector test determined that
Johan
was a lie.
Cavalhan.
The hills, you ain't right. The hills.
So you're here on
What
a
up, Kyle?
charge. These are add-on charges, attempted burglary of a structure and criminal mischief more than 200. Do you have an attorney?
I think they appointed a public defender.
Okay, do you want the public defender on these charges as well?
Yes, ma'am.
What up,
Okay, I'm gonna
FL
put the public
County
defender to
country
represent
boy?
you. I have previously reviewed the affidavit. I do find probable cause. You have a bond of $5,000 on the attempted burglary, $1,000 on the criminal mischief. Prior pretrial release conditions are going to be in effect for these charges as well, okay?
I mean,
Thank you.
at one point, they're gonna tell me how many things is coming, or it was 1, now it's 2, now it's 3, now it's 4, it was 12, he got 2 wrong, they got it released. You know, how many things
Sir?
are gonna come up?
If you want to do this, we can do this, but you're not going to like how it ends because you're interrupting my court. You're preventing me from continuing my court because you keep getting charges, and we can go into contempt of court proceedings if that's what you would like.
Let's
which is
go.
Separate charges where I can hold you up to 179 days in jail. So is that
179?
what you want to do?
Is that
I
it?
don't understand, you know, they keep
Okay,
saying different things.
thank you.
No
Move to the left.
Nintendo. Next! Get out of my face. Yeah.
Juan
She
Crespo,
she dropped that fool's
And,
nuts
Sanderson let finish all this. I don't know if
like a sack of rocks.
ma'am.
the victim is here. She contacted our office yesterday as well as the state's office.
What up,
Wanting
Carson?
to have
I'm here
contact.
online.
I told her that, well, she's
Mic
like
drop.
in this case. I guess she's appearing online. I think she wanted to be heard by the court regarding this matter.
Now that's to be heard as well.
That lady kind of sounds like Ashley
Where's the-
Stinson,
where's
if you
the
will.
victim's name?
It is a Jasmine Rivera.
I'm here.
Just Judy in the building. That's right, Kyle. Hey, you know what?
Can you put your camera
It's
on?
it's been kind of slow up in Polk County, if
Mr.
you will.
Rivera?
Yesterday and today,
Yes.
the numbers have definitely gone down. I wonder what's going on with the census, if you will.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Ashley's cousin.
All right, thank you. Put your hand down. Let me get to the point where you can speak. But let me go through this first. All right, so Mr. Crespo, you were here on an arrest
Hillsborough
warrant
County.
issued by the Honorable Judge Franklin for possession of burglary tools with intent to use, criminal mischief, armed burglary of a dwelling structure or conveyance, aggravated assault with a deadly weapon, possession of a firearm by a convicted felon, and battery.
That fool's going to
Do you have
prison.
an attorney, sir?
Not at the moment, no.
You like one?
Not at the
Yes.
moment.
And are you currently employed?
Yes, ma'am.
Without that
How much
criminal
you make?
activity? What up,
1,000.
T Maria?
Do you have any dependents?
No.
There's no way he's
Just you?
employed. He's lying.
Yes.
You're not going to qualify for the public defender, so you're going to have to hire an attorney.
You can't get into other page?
I have previously reviewed the warrant. There is probable cause.
What up, Angelica?
And Ms. Rivera, you wish to be heard. What is it you would like the court to take into account?
I do. I recanted my statement.
Recanted?
I was not on my medication and I was drinking.
The plot
So
thickens.
there was things that were there that were not really there. And Juan didn't do anything to me. There was no broken
Gail.
entry. He also resides in this house. My mom wrote a statement, submitted her IDs to you guys as well.
Ma'am, hold
so you
on,
guys
ma'am,
can-
ma'am, I need you to stop talking for a moment.
This guy's
You do
screwed.
understand that you are in a court of law. You do understand that you are under oath at this time. And you do understand that anything that you say can and will be used against you. You have the absolute right to remain silent. If you
Eh.
choose not to remain silent, anything that you say right now can be used against you in potential criminal proceedings.
Nicole, thank
Do
you.
you understand that?
Tasha, thank you for the
Yes,
follow.
I understand.
Okay. You may continue if you choose to do so. The court would.
She's
based
having
on what
buyer
you say,
remorse.
Recommend that you don't, but you can do whatever you choose to do.
But I love
press any
him.
charges. And I recanted my statement, and the public defender has it, and so does the state attorney.
Okay.
10 toes down.
State, you wish to be heard?
Yes, Your Honor. With regard to the charge of armed burglary, that is a burglary of a dwelling. A burglary of a dwelling is an enumerated dangerous offense under 907-041. Also, it is a punishable by life felony as charged. State is
Life?
requesting that the court exercise its
What up,
discretion
Frank?
to hold the accused no bond, as the accused is not entitled to a bond for that count. If the court is not so inclined, state will be requesting 24 hours to be held that time, the state to file a motion for pretrial detention. But also respectfully note in the court making that determination, I would note that the affidavit before the court indicates that the accused has currently open 2 other felony cases, one out of Osceola County and one out of Orange County. I did pull a CCIS report on the accused. The open charges in Orange County are possession of firearm by convicted felon, possession of cocaine with intent to deliver, driving with suspended license, possession of drug paraphernalia, leaving the scene of a crash without giving information. It would appear that this charge would violate any release terms, but of course that's an Orange County matter. Also, the Osceola case appears to still be open, even though it is a 2015 case. The charges in that are burglary of a dwelling, conspiracy to commit burglary of an occupied dwelling, grand theft from a dwelling, resisting an officer without violence, and criminal mischief.
That's like 1,000
Also,
years.
note that the accused has a substantial and lengthy,
Probably like 3 life
including
sentences too.
violence and including numerous burglaries, most of them out of Orange County or Osceola County, not in Polk County, and also grand thefts from the dwellings and dealing in stolen property convictions.
This guy has a criminal charges longer than a
convictions.
CVS receipt
Also a
during the
conviction
holidays.
for escape. That was in 2014 in Orange County. I'm not going through the entire history, but burglaries, thefts, going way back, Judge, at least a decade. I'd also note that the whole order in Osceola, when Osceola served the warrant from Polk County, the officer made a note that while non-secure, the accused attempted to abscond from the corrections facility by attempting to escape from the patrol car. Taking
And he's a
that,
Houdini?
the warrant, the open cases,
What up, Drills?
substantial history of the state would ask the court to
What up,
exercise
miss?
discretion in holding the accused no further proceedings. Certainly, I understand what the victim has stated, but the state would also respectfully
They blocked it, Drills.
ask the court to order no victim contact, at least until further proceedings. I do not know whether any of the numerous burglaries involved this same
Community service in
They
Scotland,
are
family man.
out-of-county, charges, so it will take some time for the state to figure that out in this county. And I would assert that the defendant's release would pose a great danger to the victim, despite what the victim has said.
It's all good. Thank you.
I would also respectfully point to the allegations in the police report, which states that there was physical evidence supporting the statement that the victim gave at the time of the reporting. That is contrary to what the victim has stated remotely before the court today. Thank you.
Damn, finally done.
Your Honor, may I speak?
Anything that you say can and will be used against you.
I can't wait for this.
I would encourage you not to, but you certainly
That's fine.
may.
Yeah, all the stuff that he's speaking about, I was 18 years old, and also I am on the lease at that house, and she put my toolbox out of the house. All that stuff, you can finish talking with her, but I didn't do
I'm
nothing
done
that
talking
day.
with Ms. Rivera. She said her piece
That
to the
is
court.
correct.
Anything further?
Yes, I'm not
I-
a threat or nothing. I
Rivera,
work
I'm-
every day.
Ma'am, you had your opportunity to talk and we're done talking right now. Mr. Crespo, anything further?
Yes, I work every day, and all those charges are when I was 18 years old. I've been finished those long time ago.
Forget about those
And I
charges.
work every
Think about the
single
new
day.
ones.
Own my own business, and I'm
Not
not a threat
anymore.
to anybody. I'm not. This is. I don't. Anything I'm saying, you can't use against me because I didn't do
Sir,
nothing.
do you have anything to say regarding the bond or anything like that?
Yes, if I could please bond out, and I will adhere to any conditions. I'm not
A
threat
threat.
to anybody. I didn't do nothing.
Nada.
Well, this is an arrest warrant where another judge determined probable cause, found probable cause, signed the arrest warrant, and I am not going to change anything relating to another judge's warrant.
Yes,
So I
ma'am.
have reviewed it. I do find probable cause. As to the charge of possession of burglary tools with intent to use, you have a bond of $5,000. Criminal
5,000.
mischief, $250.
250.
Aggravated assault with a deadly weapon, $5,000.
10,000.
Possession of a firearm by a convicted felon, $15,000.
25.
Battery, $1,000. As to the armed burglary of a dwelling, at
26.
this time, you are going to be held no bond. If you are able to get a bond at a later date, you will be placed on pretrial release. You must report the day of or morning after your release and report every Tuesday. In addition to the standard conditions of pretrial release, you are not to use, possess, or carry firearms, guns, weapons, ammunition, or knives, and you are to have no contact with the victim directly or indirectly, in person, in writing, by telephone, pager, fax, text, email, social media, or through third person. You must stay 500 feet away from the victim's home, vehicle, place of employment, and or school at all times. You may return to the residence one time within 48 hours of your release from custody, accompanied by law enforcement, to get any of your personal belongings. All right,
Excuse
thank
me,
you.
ma'am.
Your Honor, can I say something?
But wait, there's more.
Excuse me, Your Honor.
But wait, there's more.
Step two left, she says.
No, you
There
had
was
your
no
chance to speak.
burglary. There was no burglary at all.
Yeah, there's no
You're
burglary. I
about
don't
to-
have no
you're about to
gun.
be held in
Tase
contempt of
him.
court as well. Do not
How
think
do I
that you
get a
cannot
bond?
be held in contempt of court because you're not the defendant. Both of you are interrupting my court proceedings, and I am done.
Put a fork in them.
You had your chance to be heard. Now it's time to move on. I have
She's big mad.
66 other people.
66.
I apologize for that.
Who?
Let's move on to.
You're in your right, Your Honor.
Donaldson.
Tase him now. Chad.
Sir, you're here on a charge of possession of paraphernalia, possession of methamphetamine, and possession of fentanyl. Do you have an attorney?
No, ma'am.
Do you like one?
Yes, ma'am.
Are you currently employed?
Yes, ma'am.
Hey, they're really testing
much
our
do you make in a week?
patience today.
Like 650.
650.
Do you have any dependents?
No, ma'am.
It's just you?
Yes, ma'am.
I'm going to provisionally appoint the public defender to represent you. I have previously reviewed the affidavit. I do find probable cause. You have a bond of $1,000 on the paraphernalia, $5,000 on the methamphetamine, $5,000 on the fentanyl. You're currently out on bond and pretrial release in CF 262068.
Yeah, Bando, he ain't going nowhere.
Revoking that and holding you no bond, Parker v. State.
And
I'm not on bond.
not sure
You're not
they're
on
the
bond?
same person.
I'm not on bond.
Looked at their pictures on the sheriff's website, and I'm not quite sure that the other case is under a different name of Jamie and Bibbs.
Yeah, they. Oh,
I mean, I don't know that that's the same person as when I looked at the sheriff's website for both of them. That I don't think it's the same person. So I would,
You looked at the pictures?
yes, I can.
Hey, thank
pull
you,
them up
Lisa.
Again, let's see.
Where did you get this?
I'm not sure how much money you have to make to not to qualify for a lawyer or public pretender, if you will.
Sure, sure. I'll show you the one. This is him right here.
Yeah.
Obviously, that's him.
Okay.
Mr. Donaldson.
I can't see, Your Honor.
Okay.
But if we look at the other picture of the Bibbs, I wish I could pull them up at the same time.
Hey, you're
but
welcome,
I don't know
Lisa,
how to do
anytime.
that. But
Yeah.
Dan Bibbs was booked in and booked out, and this is what he looks like.
Quite different.
I just don't think they're the same person, but I mean, that was just my opinion on looking at the two photos. I just don't feel comfortable with him being Parker when it may not be the same person.
What was that?
That was recently.
That was just.
You are
that was
not
just-
the boss.
I don't know if it helps at all, but we contacted the booking clerks and they did give us an AKA form if you would like to view that.
Well, I know that it's an AKA of his.
It's just that the pictures don't look the same.
EA Sports.
If you
It's in
want
the
to
game.
look at the
I'll tell you, I'm not gonna park you right now. So you do have bonds on those cases, charges, okay?
yes, ma'am.
All right, thank you, sir.
Thank
Anthony Ettinger,
Anthony, come on down. Anthony has a walker. Oh, he has a fancy one. I wish they would have given me one of those when I got out of the hospital.
So you're here on violation of probation for your prior charges of possession of methamphetamine and possession of paraphernalia. Do you have an attorney, sir?
No.
Like one?
Yes.
Are you currently employed?
No.
I'm going to appoint the public defender to represent you. I have previously reviewed the affidavit. I do find probable cause, and at this time you are being held no bond, sir. Thank you.
Okay.
Gavin Ledbetter?
Damn, that fool's doing big things with that walker, man. I'm telling you, I wish I had one of those. I had to have the
Sir,
ones
you're
with no
here in
wheels.
Violation of probation for your prior charge of fleeing or attempting to leave high speed. Do you have an attorney?
No, ma'am.
Like one?
Yes, ma'am.
Are you currently employed?
No, ma'am.
Then appoint the public defender to represent you. I have previously reviewed the warrant. There is probable cause, and at this time you are being held no bond, sir.
Yes, ma'am. You have a good day.
You. Edward Snipes?
Edward Snipes.
Senior Assistant Defender's Office. I have a stipulation with the state regarding both charges.
Hey, what up, man?
That there's probable cause for just a battery on person over 65 and an assault on person over 65 without the domestic part of it.
What up, Bear?
Sir, you're here on charge of domestic violence battery on person over 65 and domestic violence assault on person over 65. Do you have an attorney?
No, ma'am.
Would you like one?
Hey, what up, Arturo?
Do you want an attorney?
Yes, ma'am. Public defender.
A public defender? Are you employed?
But ma'am, can I ask you a question?
Are you employed,
Oh.
sir?
Yes, ma'am. I get Social Security.
Okay, is that all your income? Is just Social Security?
That's not employment, having Social Security.
Okay, I'm going to appoint the public defender to represent you. I have previously reviewed the affidavit. I am in agreement with state and defense. I do find probable cause for battery on person over 65 and assault on person over 65.
Why?
You have a bond of $5,000 per count. If you are able to bond out, you will be placed on pretrial release. Report the day of or morning after your release and report every Tuesday. In addition to the standard conditions of pretrial release, you are not to use, possess, or carry any firearms, guns, weapons, ammunition, or knives. You're to have no contact with the victim directly or indirectly, in person, in writing, by telephone,
What up,
pager,
Nikki?
fax, text, email, social media, or through third persons.
I'm doing pretty good.
Stay 500 feet away from the victim, victim's home, vehicle, place of employment, and or school at all times. You may return to the residence one time within 48 hours of your release from custody, accompanied by law enforcement to get your personal belongings. Yes, sir, you had a question?
Pre-trial is like
Yes,
being on
ma'am.
GPS, having a GPS tracker on your leg.
Charge me with a battery when the house is mine. My
That
name
doesn't
is on the house.
That doesn't mean you can put your hands on people, sir.
Hey, thank you, Chad.
All right, thank you.
But I did not put my hand on her. She was inside the kitchen, waiting on him to come inside the kitchen. And I was sitting in the front room, and he coming through and turned towards me with his fly down.
His fly?
Put his pants in my face.
Pants in your face?
Shut him up, wasn't a bad bite like that there.
Okay, sir, that, you need to talk to your attorney about that. That's not at all what is stated in the affidavit.
I seen some Pornhub
Thank you. Who else do we
movie
have?
star
South
like
County,
that.
that's the last name I have.
We have a Michael Bonnell.
Michael Bonell. Sir, you're here on a charge of possession of paraphernalia and possession of methamphetamine. Do you have an attorney?
No, ma'am.
Would you like one?
Yes, please.
Are you currently employed?
No, ma'am.
I'm going to appoint the public defender to represent you. I have previously reviewed the affidavit. I do find probable cause. You have a bond of $1,000 on the paraphernalia and $5,000 on the methamphetamine, sir. All right, thank you. That's it. Is that it at South County?
Yes, ma'am, that completes South County.
Thank you. Have a good day.
You too. Bye-bye.
Ashley Childs,
Yes, ma'am.
you're here on a charge of possession of paraphernalia and possession of methamphetamine. Do you have an
Yep.
attorney?
No, ma'am.
One,
Yes, please.
currently employed.
No.
And appoint the public defender to represent you. I have previously reviewed the affidavit. I do find probable cause. You have a bond of $5,000 on the methamphetamine, $1,000 on the paraphernalia. All right, thank you.
Thank you.
Please, Zero. All right, you're here on a charge of domestic violence battery on person over 65. Do you
Another
have an
one?
attorney?
Damn.
No.
Why?
One,
Yes, ma'am.
currently employed.
No, I'm disability.
I'm going to appoint the public defender to represent you. I have previously reviewed the affidavit. I do do find probable cause for domestic violence battery. I didn't note an age in the affidavit.
Yeah, date of the victim was listed in the demographic information on the same page. This being the only count, if the court is not inclined to, respectfully, if the court is not inclined to take that into consideration, the state will be asking for 24 hours to perfect that, as it is what elevates the case to a felony charge. State would not object to a presumptive bond in the interim.
Defense, are you going to argue the demographic information, or would you agree with it?
I would defer to the court on this. I mean, it does have the date of birth and on the second page.
Normally, I want it to be in the body. However, if the state's going to ask for 24 hours, I'll go ahead and find the probable cause so I can.
What up, John?
Ms. Cordero bond.
Or Joan?
So at this time,
John or Joan? John,
you
right?
have a bond of $5,000. If you are able to bond out,
A Nokia phone.
placed on pre-trial
Jeez.
release, you must report the day of or morning after your release and report every Tuesday.
Man, I've been using one of
In
these.
addition to the standard conditions of pretrial release, you are not to use, possess, or carry any firearms, guns, weapons, ammunition, or knives. You're to have no contact with the victim directly or indirectly, in person and writing, by telephone, pager, fax, text, email, social media, or through third persons. You must stay 500 feet away from the victim, victim's home, vehicle, place of employment, and or school at all times. And you may return to the residence.
Man, you should have tried to watch me on your what do you call it, on your refrigerator.
Questions. Do I have to leave the residence or?
You can go back to the residence.
Okay.
Thank you.
Is she covering her face? Why is she covering her face?
It's pronounced Sweeney, Your Honor. Hey.
Oh, she's stretching. She's doing those
You're
morning
on charge of
stretches.
Battery on law enforcement officer, driving under the influence and refusal to submit to a DUI testing. Do you have an attorney?
No.
Why are your hands over your face?
Because
Very bright in here.
yeah.
See, you can wait to the end.
Super bright.
Yeah.
Have a seat. She's gonna wait to the end. I'm not playing your games. Wendy
Just have a seat-
Fernandez.
Have a seat in the second cell. You'll come back and
In here?
yeah, just have a seat in the second cellar.
Yes.
Ms. Fernandez, you're here on a charge of violation of injunction for protection against domestic violence and violation of probation for your prior charge of unlawful use of a two-way communication device.
Another
Do you
one.
have an attorney?
Yes.
Who's your attorney?
Kevin Cox.
Okay, and do you want to proceed today without him, or do you want to try to come back tomorrow and get in touch with him?
I'll proceed today.
I have previously reviewed the affidavit. I do find probable cause. You have a bond of $5,000 on the violation of injunction, and you're being held no bond on the violation of probation, ma'am. Thank you. Shantara Glover,
Yes.
ma'am, you're here on a charge of failing to carry motor vehicle liability insurance. Do
What
you
up,
have an
Boston?
attorney?
No.
Like one?
Yes.
Are you currently employed?
No.
I'm going to appoint the public defender to represent you. I have previously reviewed the affidavit. I do find probable cause. You have a bond of $500. I also see that you're currently out on bond in CF 259597. This time I'm revoking that bond and holding you no bond per Kirby State. Thank you.
She ain't going
Cynthia
nowhere.
Johnson,
Yes, ma'am.
you're on a charge of possession of methamphetamine and possession of paraphernalia. Do you have an attorney, ma'am?
No, ma'am.
Like one?
Yes, ma'am.
Are you currently employed?
I'm not employed, but I work with a lady named Sue and do side jobs with her.
Okay, about how much do you make a week?
What the hell does that have to do with anything?
$250.
$250 a week.
Public defender to represent you. I have previously reviewed the affidavit. I do find probable cause. You have a bond of $1,000 on the paraphernalia and $5,000 on the methamphetamine, ma'am.
Okay.
I can't even fill up my gas tank with $250 a week.
Yes, ma'am.
Ma'am, you're here.
I've
on
never done
violation of
Hillsborough.
Probation for your prior charges of possession of methamphetamine, possession of cannabis, possession of
What happened?
paraphernalia, possession of hydrocodone, possession of cannabis, and possession of paraphernalia. Do you have an attorney?
I believe that the public defender's office came and met with me yesterday and for the application.
I do see that the public defender's office is appointed.
Smoke
Your
weed
case.
every day.
I have reviewed the affidavit and warrant. I do find probable cause, and you are being held no bond still, ma'am, okay?
Shit.
Yes, ma'am.
Thank you. Denise Lanston,
Yes, ma'am.
ma'am, you're here on Failure to appear capias issued by the Honorable Judge Pinkett for battery, burglary, robbery, and resisting officer with violence. I'm showing that you previously were appointed the public defender. I have reviewed the capiases. There is probable cause. At this time, you're being held no bond. You are scheduled for a hearing. It looks like on the 14th, though, with Judge Pinkett for her to determine if she's going to give you a bond, okay?
Yes, ma'am. Thank you.
Deidre O'Neill.
Sandra Smith, Public Defender's Office. My understanding is the alleged victim wants to have contact with her, so I was gonna ask for no violent contact.
Ma'am, you're here on a charge of domestic violence battery with a prior conviction. Do you have an attorney?
No,
Do you like one?
yes,
Are you currently employed?
no, I'm
Okay.
retired.
Okay, I'm going to appoint the public defender to represent you. I have previously reviewed the affidavit. I do find probable cause.
She seems so sweet and innocent. But little do you know that she's toting one of those stang things around. And she might put some lead steel in you, if you will. If you come at her sideways. How do you guys think she holds it? Like this proper, or does she hold it sideways?
Okay. At this time, you have a bond of $5,000. If you're able to bond out, you will be placed on pretrial release. You must report the day of or morning after your release and report every Tuesday. In addition to the standard conditions of pretrial release, you are not to use, possess, or carry any firearms, guns, weapons, ammunition, or knives. You're to have no
90.
contact with the victim directly or indirectly, in person, in writing, by telephone, pager, fax, text, email, social media, or through third person. You must stay 500 feet away from the victim, victim's home, vehicle, place of employment, and school at all times. You may return to the residence one time within 48 hours of your release from custody, accompanied by law enforcement, to get your personal belongings.
Wow. Hey, I'm feeling pretty good after the procedure. They took out that last stint yesterday out of my pancreas, if you will.
Yes, ma'am.
You're here on a charge, add-on charges of resisting officer with violence, battery on law enforcement officer, and resisting officer without violence. Looks like, do you have an attorney, ma'am?
I put in for one, but they failed it, and I'm waiting on somebody to come see me, ma'am. I'm still waiting on somebody to come see me, ma'am. The public defender.
You employed?
I get Social Security. I get Social Security.
She doesn't work with Sue?
And I'm going to appoint the public defender to represent you. I have previously reviewed the affidavit. I do find probable cause. You have a bond of $5,000 on the resisting with violence, $5,000 on the battery, and $1,000 on the resisting officer without violence.
Hey, Simply
When will
Kate,
be
I'm
my
feeling
next
way
court
better.
date, ma'am, because this is not true.
I
I did
don't
not.
know. You have to look at the kiosk there.
Kiosk.
Thank you. Candace Reed,
Yes, ma'am.
and you're here on a violation of pretrial release capias issued by the Honorable Judge Gibson on your charge of battery. Do you have an attorney?
I do.
Who's your attorney, ma'am?
Antoinette Palma.
Okay, do you want to proceed today without that person, or do you want to contact them?
Defender,
Oh,
I'm
that's a
sorry.
public defender?
Yeah, it's a CLI.
Oh,
Well,
I was gonna say, I didn't recognize that name.
Yeah.
Okay.
But we're appointed.
So it is a public defender.
Oh,
Okay.
hey, thank you, Raven.
All right, I have previously reviewed the capias. There is probable cause. At this time, you're being held no bond. You do have a court date, looks like on the 10th, to go in front of that judge to determine if they're going to give you a bond or not, okay?
Is that in the morning, Your Honor? Or
It's 8:30.
Thank you.
All right, thank you, ma'am. Heather, register.
Sandra Smith, Public Defender's Office, Your Honor. In this case, she and the alleged victim, Jones Vinson, you'll be calling later, were both charged in the same incident. And I did review the victim comment sheets for both of them. They want to have contact with each other, so I was just going to ask for straight pretrial release with no violent contact for both of them.
All right, ma'am, you're here on a charge of domestic violence battery. Do you have an attorney?
Hey, what up, Siwa?
Not exactly sure.
Don't cry
You want
now.
an attorney?
Sure.
Okay, and are you employed?
Yes.
Not anymore.
About how much money do you make a week?
400 a week.
400?
I'm going to go ahead and appoint the public defender to represent you. I have previously reviewed the affidavit. I do find probable cause. State, do you wish to be heard?
No, Your Honor, thank you.
All right, this time I'm going to release you straight pretrial release.
Release?
Report the day of or morning after your release and report every Tuesday. In addition to the standard conditions of pretrial release, you may have contact with the victim, but you may not be physically or verbally threatening, violent, or
wow.
abusive in any manner.
Why is she giving her a break?
Sanders Smith, Defender's Office. I do want to.
That's what I want to know.
Of her charge as a second-degree felony, and do want to waive the reading of any special conditions of pretrial release.
Don't waive.
All right, ma'am, do you know what you're here for?
No.
No, I thought the case was dismissed.
Well, no, it's not. Can somebody please show her the charge so she's aware of what she's charged with?
Hey, what's the
And
federal?
They're gonna show you the charge, okay? Just read it. You don't have to say anything out loud. Just read it. Let me know when you read it.
Read it out loud. Read it.
Lewd?
Nude. Lewd?
Here we go. Yes, you're here on a charge of,
Charge of what?
yes. Do you have an attorney?
Did she say lewd or
No,
nude?
not at the moment.
Would you like one?
No.
Okay, if you change your mind, let the judge know.
All
I have
right.
previously reviewed the affidavit. I do find probable cause. State you wish to be heard?
Yes, Your Honor, with regard to the single count, that respecting request from defense counsel. This is a qualifying offense under 907.041, is an enumerated dangerous offense, and it is an F2. State is filing a motion for pretrial detention. I have a copy for defense counsel once they are identified. May I approach? I respectfully request court review this motion for facial sufficiency. The court finds it facially and legally sufficient. State last that this defendant be held no bond pending hearing on this motion, to be heard next Monday at 1 o'clock on the A2 docket. I've already forgotten the date for next Monday, but it is April 13th.
All right, I have reviewed the motion for pretrial detention. It is facially and legally sufficient. So at this time, you are going to be held no bond. You'll have that hearing next Monday, and that judge will determine what bond you'll get and any conditions that might go along with it, okay?
Okay.
Thank you. Catherine Santana?
Yes.
Right. Ma'am, you're here on a charge of trespassing an occupied structure, resisting officer without violence, and petty theft. Do you have an attorney?
No, but how do I get trespassing if I was never trespassed from there?
Okay, would you like an attorney?
Yeah, sure.
And are you currently employed?
No.
Okay, I'm going to appoint the public defender to represent you. I have previously reviewed the affidavit. I do find probable cause. You have a bond of 1,000 on the trespass, 1,000 on the resisting, and 500 on the petty theft, ma'am.
Oh, he gave me all these charges, bro. What the fuck? I didn't even resist
She said,
him.
bro.
Get back here right now.
WTF.
You understand that you are in a court of law and that language is not acceptable and will not be tolerated.
I didn't even say no bad language.
I can pull it back and I know exactly what I heard.
Pull it back,
Okay,
Judge.
All I said was I didn't
Ma'am,
resist him
Stop talking.
and I didn't do
Stop
nothing wrong.
talking.
Bro.
You can be upset all you
WTF.
want, but you will not disrupt my court.
Tell her, Your Honor.
I suggest you get her out of here very quickly.
Taser. I like Florida. I love these
Shannon?
outbursts.
Sanders Smith, Defender's Office. She's been recommended for straight pretrial release, and I don't see that she has any prior record. I was going to ask for straight pretrial release also.
Ma'am, you're here on a charge of domestic violence battery. Do you have an attorney?
Not at the moment.
Like one?
Yes, ma'am.
Are you currently employed?
Yes, ma'am.
Hey, we think
How much
alike,
you make
Chad.
a week?
About $500.
Okay, I'm going to appoint the public defender to represent you. I have previously reviewed the affidavit. I do find probable cause. State, do you wish to be held?
No, Your Honor, thank you.
At this time, I will release you straight pretrial release. You must report the day of or morning after your release and report every Tuesday. In addition to the standard conditions of pretrial release, you are not to use, possess, or carry firearms, guns, weapons, ammunition, or knives. And you're to have no contact with the victim directly or indirectly, in person, in writing, by telephone, pager, fax, text, email, social media, or through third persons. You must stay 500 feet away from the victim, victim's home, vehicle, place of employment, and or school at all times.
Yes, ma'am. Am I able to receive this in writing if possible?
Yes, everything's going to be in writing for you.
Absolutely. Thank you.
Victoria Williams.
Hello.
And you're here on an arrest warrant issued by the Honorable Judge Corbett. for charges of aggravated assault with a deadly weapon, unarmed burglary of occupied structure, and criminal mischief.
What up,
Do you have
Bradshaw?
an attorney?
I do not believe so.
That's
You
right,
like
Jess.
one?
I would.
And are you currently employed?
I
What up, Crypto?
How much do you make a week?
$350.
$350.
Can I appoint a public defender to represent you? I have
Can I
previously.
make a comment?
Excuse me?
Can I make a comment?
Yeah, go ahead.
Not till I'm done talking, and please don't interrupt me again.
What up, Sass?
My apologies.
I have previously reviewed the affidavit. I do find probable cause. You have a bond of $5,000 on the aggravated assault, $15,000 on the unarmed burglary, $5,000 on the criminal mischief. You are able to bond out. You will be placed on pretrial release. You must report the day of and morning after your release, and report every Tuesday. In addition to the standard conditions of pretrial release, you are not to use, possess, or carry any firearms, guns, weapons, ammunition, or knives. And you're to have no contact with the victim directly or indirectly, in person, in writing, by telephone, pager, fax, text, email, social media, or through third persons. You must stay 500 feet away from the victim, victim's home, vehicle, place of employment, and or school at all times. Anything that you say can and will be used against you. If you wish to say something, you can do so now.
Part-time jobs, Frank?
Well, I did want to clarify that I did not steal or break into a structure, but I accept the charges. I'll talk about it with my attorney.
You got no choice.
Alex Alejandro.
Alex Alejandro, come on.
All
Damn.
right, sir, you're here on a charge of driving under the influence with crack alcohol 0.15 or higher.
He looks a
Do
bit
you have an
zesty, if
attorney?
you will.
No, ma'am.
Like one?
No, ma'am.
If you change your mind at a later time, let the judge know. I have previously reviewed the affidavit. I do find probable cause. You have a bond of $1,000. If you are able to bond out, you will be placed on pretrial release. You must report the day of or morning after your release, and report every Tuesday.
Hey.
Listen to the standard conditions of pretrial release. You are not to possess or consume alcohol or enter any bars and lounges. You will be subject to
He
random
dropped the
driving
soap.
license.
Hey, what up, pretty Ricky? Thank you.
Julian Alistair.
Yes, ma'am.
Sir, you're here on a Hillsborough County failure to appear capias for domestic violence battery. I have previously reviewed the affidavit. I do
Why?
find probable cause. Looks like you have a bond of $2,500. So if you can bond out, you can do so. If not, we'll notify Hillsborough County that you're ready for pickup. And if you're still here on the 14th, we're going to bring you back to see if we're going to release you, okay?
Okay, thank you very much.
I understand that well.
Assistant Black? Black, you're here on a violation of probation for your prior charge of trespass and battery. Do you have an attorney?
No, ma'am.
Like one?
Yes, ma'am.
Are you currently employed?
Yes, ma'am.
How much do you make a week?
Approximately about 550.
550?
I'm going to appoint the public defender to represent you. I have previously reviewed the warrant. There is probable cause, and at this time you are being held no bond. Thank you.
See on that.
Sean Boone.
Sandra Smith, Public Defender's Office. I have a stipulation with the state that on one of the paraphernalia charges, that he can be ROR'd on one of the counts. The state is requesting that probable cause be found for all charges, but on one of the paraphernalias, he can be ROR'd.
All right, so sir, you're here on a charge of unlawful.
What up,
possession
Bill?
of
Cool
shopping
things.
cart, 2 counts of possession of drug paraphernalia, and possession of methamphetamine. Do you have an attorney?
No, ma'am.
Would you like one?
Please.
Are you currently employed?
Yes, ma'am.
How much are you making a week?
About 450, 500.
Okay, I'm going to appoint the public defender to represent you. I have previously reviewed the affidavit. I do find probable cause. You have a bond of $1,000 on unlawful possession of a shopping cart, $1,000 on possession of
Shopping
paraphernalia.
cart?
You're going to be ROR'd on the second count of drug paraphernalia, and then $5,000 on possession of methamphetamine, sir. All right, thank you.
That's an outrage.
Anthony Beso,
Wesso, yes, ma'am.
sir, you're here on a charge of criminal mischief, attempted burglary of a conveyance, simple assault, possession of cannabis, and possession of paraphernalia. Do you have an attorney?
No, I don't have an attorney.
Do you like one?
Yes, ma'am.
Are you currently employed?
Yes.
How much are you making a week?
About 400 to 500 a week.
I'm going to appoint the public defender to represent you. I have previously reviewed the affidavit. I do find probable cause.
I definitely wouldn't be able to live off of $400 or $500.
An extra charge.
I don't know. It's hard. I don't know. $400 or $500 a week.
Yeah, because I don't have that resisting charge. In just a moment, or maybe an extra or an amendment.
Go back to the bathroom.
They could lie, yeah,
Okay,
they
see, it's on
can.
this one. Okay. Did I catch it?
Gotcha.
I mean, I know I would lie. I wouldn't be saying. I'd be saying the same thing. I'll probably even be making less. They are criminals, so hey, I mean, why wouldn't they lie, right? Right, guys? You gotta get into the mind of a criminal.
Okay, so you're also charged with resisting the officer. Who's speaking right now?
No sé. I don't know.
I'm sorry, ma'am, I didn't hear you.
I know because somebody was speaking who shouldn't be speaking. Apparently they muted their device before I could kick them out. I apologize. Give me just 1 second. It looks like the clerk has an additional charge of resisting officer without violence. And I'm rereading the affidavit to see if I find probable cause for that.
Is he booked in on that charge?
Yeah.
Bless
That's
me.
what I'm trying.
It's on the affidavit.
I mean, not on mine.
Yeah, it wasn't mine either.
I only have the one.
It's not on mine, that's what I said.
I didn't realize there was more than one.
I mean, it looks like they have a new book-in sheet for him.
I'm not seeing the
I
resisting.
see the new one. I don't know, this is happening a lot lately where they add charges at the last minute. Just one moment.
Correct me where the resisting is in this report, because I'm not seeing that.
Judge, if I may, I've read the affidavit that includes the resist officer without violence count. It is on the face of that affidavit. I have read the accompanying narrative as well. Do not see any reference to a resisting charge. So typically I'd ask for more time, but because there's no mention of it at all, then I would stipulate there's not probable cause stated in the affidavit. There may be an affidavit that'll follow, so that charge may stick around, but I don't see it at this time.
Okay. Okay, so I have reviewed now the full affidavit. I do not find probable cause for the charge of resisting officer without violence, so you will be ROR'd on that. I do at this time find probable cause for the remaining charges. You have a bond of 500 on the criminal mischief, 5,000 on the attempted burglary, 500 on the simple assault, 1,000 on the cannabis, and 1,000 on the paraphernalia.
There was a live chase, Hector?
All right, thank you, sir.
Thank you, ma'am.
I love them live chases.
Jeffrey Chauncey,
Release on all recognizance, if you will.
you are here on violation of pretrial release condition, habeas issued by the Honorable Judge Carpenini for your charges of possession of a canceled or revoked license, resisting officer without violence, possession of paraphernalia, possession of fentanyl, possession of methamphetamine, and possession of a firearm or ammunition or weapon by a convicted felon. I'm showing that you have Mr. Cox as your attorney. Is that correct?
Amen.
You want to proceed today without him, or do you want to try to get in touch with them and come back tomorrow?
I thought we had a court date within 4 days, so I'll just continue.
Okay. All right, so I have reviewed the capias. There is probable cause. You are being held no bond, but you are correct. You do have a 5-day hearing, so you're going to be in court on April the 10th, okay?
Yes, ma'am. Thank you.
Thank you.
Who?
Abe Lincoln.
Have Tomo Rera Eaton.
Yes.
I don't.
All right, sir, you're here on a violation of probation for your prior charge of felony battery. Do you have an attorney?
No, ma'am.
Like one?
Yes, ma'am.
You're currently employed.
No, ma'am.
Okay, I'm going to appoint the public defender to represent you. I have previously reviewed the warrant. There is probable cause, and at this time you are being held no bond, sir. So, thank you. Jose Encarnacion.
Yes, ma'am.
Sir, you're here on use of medical marijuana in a vehicle and possession of paraphernalia.
Smoke
Do you
weed
have an
every
attorney?
day.
Negative.
You like one?
No, ma'am.
If you change your mind at a later time, let the judge know.
What up,
I have
Tracy?
previously reviewed the affidavit. I do find probable cause. You have a bond of 5,000 per count. All right, thank you. Olivero Garcia.
Yes, ma'am.
Sir, you're here on a violation of probation for your prior charge of scheme to defraud. Do you have an attorney?
No, ma'am.
You like one?
No, ma'am.
If you change your mind at a later time, let the judge know. I have previously reviewed the warrant. There is probable cause, and at this time, you are being held no bond, sir.
What's up with these guys? Are these guys all going to represent
Gibson?
themselves and go pro
Yes,
per?
Your Honor.
Sir, you're here on a charge of trespass. Do you have an attorney?
No, I did not.
You like one?
Yes, Your Honor.
Are you currently employed?
Not at the present time.
Okay, I'm going to appoint the public defender to represent you. I have previously reviewed the affidavit. I do find probable cause. You have a bond of $1,000, sir.
Thank you.
James Irish.
Yes, ma'am.
All right, sir, you're here on a failure to appear capias issued by the Honorable Judge Hill for your charge of grand theft and falsely identifying self as a contractor.
What's up,
You
Roxy?
showed
Yeah.
you previously were appointed the public defender. I have reviewed the capias. There is probable cause. At this time, you're being held no bond. You do have a hearing scheduled on April the 10th at 1 p.m. with that judge for him to determine if he's going to give you a bond or not, okay?
Okay, thank you, ma'am.
Cecil Kennedy.
Yes, ma'am.
All right, sir, you're here on a charge of possession of methamphetamine, possession of cannabis, and possession of paraphernalia. Do you have an attorney?
Smoke weed every day.
Do you like one?
Yes, ma'am.
I'm sorry, I couldn't hear you.
Yes, ma'am.
Is that a yes?
I don't think he has his dentures
Do
on.
you have any source of income?
Yeah. Not gonna say welfare, but $1,000 a month.
About 1,000 a month, okay. I'm going to appoint the public defender to represent you. I have previously reviewed the affidavit. I do find probable cause. You have a bond of 1,000 on the cannabis, 1,000 on the paraphernalia, and 5,000 on the methamphetamine, sir. Thank you.
What up, Tammy?
William McDonald.
Yes, ma'am.
This judge is
Sir,
definitely
you're
trying to get
here
off.
On a St. Lucie County violation of probation warrant on your previous charge of burglary of a dwelling. I have reviewed the affidavit. I do find probable cause. At this time, you're being held no bond. So we're going to notify St. Lucie that you're ready to be picked up. If you're still here on the 14th, we're going to bring you back to court to determine if we're going to release you, okay?
Yes, ma'am. Thank you.
Ryan McPherson.
Yes, ma'am.
Sir, you're here on a charge of possession of paraphernalia and possession of methamphetamine. Do you have an attorney?
No, ma'am.
You like one?
Yes, please.
Are you currently employed?
No, ma'am.
Okay, I'm going to appoint the public defender to represent you. I have previously reviewed the affidavit. I do find probable cause. You have a bond of 1,000 on the paraphernalia and 5,000 on the methamphetamine, sir.
Thank you.
Yes, sir. Sherry Anand Mohan.
Yes.
Sir, you're here on a charge of driving under the influence and refusing to submit to a DUI test. Do you have an attorney?
No.
Like one?
Yes.
Hey, in Florida,
Currently employed.
you can't refuse a sobriety
I'm gonna
test.
appoint the public defender to represent you. I have previously reviewed the affidavit. I do find probable cause. You have a bond of 5,000 per count. If you are able to bond out, you will be placed on pre-trial release. You must report the day of or morning after your release and report every Tuesday. In addition to the standard conditions of pre-trial release, you are not to possess or consume alcohol or enter any bars or lounges, and you will be subject to a random breath test.
Okay, everything will be in writing for me, right?
I'm sorry?
Yes.
Okay, thank you.
Jason Peralta?
Yes, ma'am.
All right, sir, you're here on violation of probation for your prior charges of 7 counts of burglary of an unoccupied structure, aggravated assault, grand theft motor vehicle, and willful flee to elude. Do you have an attorney?
Yes, ma'am.
Who's your attorney?
John LaGory.
Okay, do you want to try to get in touch with him and come back tomorrow or proceed today without him?
I think my family's already in touch with him today.
Okay, so what do you want to do right now?
Can we come back tomorrow?
We can come back tomorrow. Just understand that nobody here is going to get in touch with them. So either you or your family is going to have to let them know that you're coming back tomorrow, okay?
Yes, ma'am.
All right, we'll bring you back tomorrow, sir. Gary Perryman?
Yes, ma'am.
All right, sir, you're here on a violation of probation for your prior charges of possession of methamphetamine, possession of paraphernalia, and resisting officer without violence. Do you have an attorney, sir?
No, I don't.
He kind of looks like Frankenstein.
All right, would you like one?
If he painted his skin green and he had those lightning bolt or the bolts on the side of his neck.
No, I'm retired.
All right, I'm going to appoint the public defender to represent you. I
What
have
up, Teresa?
previously reviewed the affidavit. I do find probable cause. You have a bond of, or you're currently being held no bond on all of the charges, okay?
Okay, thank you.
It must be the lighting. I think it's the
Dick
lighting.
Harry?
Dick Harry.
Yes, ma'am.
Did you say
Sir, you're
Dick
here on
Harry?
the charge of domestic violence battery with a prior conviction. Do you have an attorney?
No, ma'am.
Right one?
Yes, ma'am.
Are you currently employed?
Yes, ma'am. I make about $280 a week.
Okay, I'm going to appoint the public defender to represent you. I have previously reviewed the affidavit. I do find probable cause. You have a bond of $5,000. If you are able to bond out, you will be placed on pretrial release. You must report the day of or morning after your release and report every Tuesday. In addition to the standard conditions of pretrial release, you are not to use, possess, or carry any firearms, guns, weapons, ammunition, or knives. And you're to have no contact with the victim directly or indirectly, in person, in writing, by telephone, pager, fax, text, email, social media, or through third persons. You must stay 500 feet away from
What up,
the
Tammy?
victim's home, vehicle, place of employment, and or school at all times.
Yes, ma'am.
Thank you.
Sauce. Every state is different.
Donovan
Yes, Your Honor.
Adsonpo.
Yes, Your Honor.
All right, sir, you were here on a Pinellas County warrant for driving while license suspended or revoked. An arrest warrant issued by the Honorable Judge Ramirez for written threat to kill or injure. And failure to appear capiases issued by the Honorable Judge Williamson for failure to have motor vehicle liability insurance and driving while license suspended or revoked.
No wonder my rates are so
Failure to
high.
appear capias issued by the Honorable Judge Stamey for driving while license suspended or revoked. Do you have an attorney?
I don't.
Would you like one?
I will. I do.
And it looks like on your failure to appear cases, you have the public defender. Do you wish to have the public defender on your new charge?
Yes, please.
As your
Those-
financial,
Well, I'm sorry. Go ahead.
I don't know, and it may be. I'm not sure.
at all?
No.
Okay, I'm going to appoint the public defender to represent you.
Which reminds me about car insurance. I got to call Costco. I heard that they have really cheap insurance, so my insurance is ridiculously high.
Okay.
I got 0 tickets, 0 accidents, and it's outrageous.
I
So
have previously reviewed the affidavits and warrants. I do find probable cause. You have a bond on your Pinellas County warrant of $2,013. On the written threat to kill or injure, $15,000. On the failure to appear capias issued by the Honorable Judge Williamson, you're being held no bond, but you have a 5-day hearing on that, which will be on the 10th of this month. And a $1,000 bond on the failure to appear capias issued by the Honorable Judge Stamey. If you are able to bond out on the arrest warrant, you will be placed on pretrial release. You must report the day of or morning after your release and report every Tuesday. In addition to the standard conditions of pretrial release, you'll have a curfew from 10 p.m. to 6 a.m. You are not to use, possess, or carry any firearms, guns, weapons, ammunition, or knives, and you're to have no contact with the victim directly or indirectly, in person, in writing, by telephone, pager, fax, text, email, social media, or through third persons. You must stay 500 feet away from the victim's home, vehicle, place of employment, and or school at all times.
What time is the hearing on April 10th?
8:30.
Thank you.
This isn't right. Bill and $50,000 bond. The FTA is not $1,000 bond. It's no bond.
My apologies. I heard you say the bond was stating.
The one that I had you add on is $1,000 bond.
I thought that one was with Williamson's.
Is that last one also with M4? That's what Judge Stamey. Okay, thanks. All right, thank you, sir.
Thank you.
no, thank you, Your Honor, for your service.
Jose Rodriguez Colon.
Yes, ma'am.
Sir, you're here on a charge of attempted burglary of a conveyance. Do you have an attorney?
No, ma'am.
Do you like one?
Can I get out?
Would you like an attorney?
Yes. Can I
Okay,
get an RR?
Are you currently employed?
I'm self-employed.
Okay, about how much money do you make a week?
Maybe 700, 800. All depends, ma'am, on the job.
Okay, do you have any dependents?
No, not right now.
Okay, then you don't qualify for the public defender, so you're gonna have to hire an attorney.
That's fine.
You have previously reviewed the affidavit. I do find probable cause. You have a bond of $5,000. I also see that you're out on bond in CF 25-11163. At this time, I'm revoking that bond and holding you no bond, Parker B. State. All right, thank you. Ricardo Russell. All right, sir, you're here on a charge of no valid driver's license. Do you have an
Yes,
attorney?
ma'am. No, ma'am.
Like one?
Yes, ma'am.
You currently employed?
Yes, not at the moment, ma'am.
So right now, you don't have any income?
No, ma'am.
I'm going to appoint a public defender to represent you. I have previously reviewed the affidavit. I do find probable cause. You have a bond of $500, sir.
Thank you, ma'am.
Lauren Smith?
Sandra Smith, by Defender's Office. I do want to waive the reading of the charge that he's on probation for.
Hey, sir, you're here on a violation of probation, and you know why you're on probation, right?
Correct.
Do you have an attorney?
Yes,
Who's your attorney, sir?
Lori.
Okay, and do you want to proceed today without him, or do you want to try to contact him and come back tomorrow?
We may proceed today.
I have previously reviewed the warrant. I do find probable cause. At this time, you are being held no bond, sir, okay?
May I speak, please?
And anything you say can and will be used against you.
Okay. Yeah, so when I was picked up in Lake County for the warrant and informed about what the violation was for, I was able to send proof of completion of the items that they said that I hadn't completed, which violated me. I sent those over immediately to my probation officer. He said he had uploaded everything into the system to show that I was in compliance. So,
Well, he hasn't submitted anything to the courts. So their system is completely different than our system. I don't have anything before me that says you've done anything. So that's going to have to be addressed with the judge who's going to be handling your case, okay?
okay. And what judge is that, ma'am?
I'm not sure.
Okay, no problem.
Frank Stowell?
Yes, ma'am.
Sir, you're here on 2 counts of domestic violence battery and a fugitive from justice out of Michigan. Do you have an attorney?
No.
Do you like one?
Yes.
Are you currently employed?
Yes.
About how much are you making a week?
About 1750.
Okay, do you have any dependents?
Yes.
How many?
1.
You're not going to qualify for the public defender, so you're going to have to hire an attorney. I have previously reviewed the affidavit. I do find probable cause. You have a bond of $5,000 for each of the domestic violence battery charges. No bond on the fugitive from justice. If you are able to bond out, you will be placed on pretrial release. You must report the day of or morning after your release and report every Tuesday. In addition to the standard conditions of pretrial release, you are not to use, possess, or carry firearms, guns, weapons, ammunition, or knives. You're to have no contact with the victim directly or indirectly, in person, in writing, by telephone, pager, fax, text, email, social media, or through third persons. You must stay 500 feet away from the victim's home, vehicle, place of employment, and or school at all times. You may return to the residence one time within 48 hours of your release from custody, accompanied by law enforcement to get your personal belongings. You're going to have a hearing on that fugitive from justice on the 14th, where they're going to determine if you're going to, be extradited or what you're going to do. Okay.
Okay.
Thank you, sir.
I have a question, ma'am.
Yes.
So with the warrant from Michigan, if I would bond out, do I get released until the 14th? I don't know
This
how
time,
that
no.
works.
At this time, no, because you're being held no bond on that one.
Okay.
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 So you may
Thank
want
you.
to see what happens at that hearing.
Okay.
All right, John Svensson.
Sanderson Flood Defender's Office asking for straight pretrial release and no violent contact with Miss Register who was called earlier.
Sir, you're here on a charge of domestic violence battery. Do you have an attorney?
Yes, ma'am.
Your attorney, sir.
Kevin Cox.
Okay, and do you want to proceed today without him, or do you want to try to get in touch with him and come back tomorrow?
We can see without him.
I have previously reviewed the affidavit. I do find probable cause. State, do you wish to be heard?
No, thank you.
All right, at this time, I am going to release you straight pretrial release. You must report the day of or morning after your release, report every Tuesday. In addition to the standard conditions of pretrial release, you may have contact with the victim that you may not be physically or verbally threatening, violent, or abusive in any manner, okay? All right, thank you,
All
sir.
right. I'll let her come back to the house.
Yes, you can have contact.
Thank you.
Archie Thomas.
Oh, yes, ma'am.
All right, sir, you're here on a charge of possession of methamphetamine and possession of paraphernalia. Do you have an attorney?
No, ma'am.
Like one?
Yes, ma'am, I do.
Are you currently employed?
Not at the moment, ma'am.
I'm going to appoint a public defender to represent you. I have
Uh-huh.
previously reviewed the affidavit. I do find probable cause. You have a bond of 1,000 on the paraphernalia and 5,000 on the methamphetamine, sir.
Okay, thank you, ma'am. Okay.
John Thompson.
Ma'am.
He looks cold.
Sir, you're here on a charge of possession of paraphernalia and possession of methamphetamine. Do you have an attorney?
No, ma'am.
You like one?
Yes, ma'am.
Are you currently employed?
Yes, ma'am.
How much are you making a week?
Yes, I'm working part-time right now, $300 to $400 a week.
Okay, I'm going to appoint the public defender to represent you. I have previously reviewed the affidavit. I do find probable cause. You have a bond of 1,000 on the paraphernalia, 5,000 on the methamphetamine. I'm also showing that you're currently on probation in CF 21-7658-57 and CF 22-9814. This time I am issuing an instanter warrant and holding you no bond.
And I would ask for public defender to be appointed on those cases also.
I will appoint the public defender on those cases as well. All right, thank you, sir.
See it second, so.
Chica Finney.
Yes, I am. As soon as I'm fixing the other computer that I streamed the courts in.
She's approaching.
So I do plan on starting to stream
Honor.
Mindy again, if you will.
It's pronounced Feeney.
We're going to
My
try this
last
again.
name.
You're here on a charge of
Okay.
battery on law enforcement, driving under the influence, and refusal to submit to a breathalyzer. Do you have an attorney?
Negative.
You like one?
Negative.
Okay, change your mind at a later time, let the judge know. I have
Okay.
previously reviewed the affidavit. I do find probable cause. You have a bond of 5,000 on battery on law enforcement, 1,000 on driving under the influence, 1,000 on the refusal to submit. If you are able to bond out, you will be placed on pretrial release. You must report the day of or morning after your release and report every Tuesday. In addition to the standard conditions of pretrial release, you are not to use, possess or consume alcohol or enter any bars or lounges, and you will be subject to random breath tests. All right, thank you.
Can you repeat the number?
I don't know what number you're referring to.
Did you say for the charges, what were the bond numbers? 5,000 for each?
5,000, 1,000, and 1,000.
How many is it? 3?
Yes, ma'am.
Okay, thank you.
You know, we skipped a Miss West.
I have.
Do you guys want to watch Board of Parole hearings from Connecticut?
Her classifications, I'm sorry, Your Honor, I called about her earlier. Classifications called court holding and had them have her removed from the list.
She doesn't want her face to be seen.
I don't know why, other than.
I didn't know that she needed to be reset for tomorrow, or is she just not supposed to have a?
All right. Stay tuned. Don't go
All I know is
nowhere.
that the clerks over at the processing center called and had her removed from the docket.
I'll put her on for tomorrow.
Thank you.
And Yarbrough bond.
All right.
That was it.
Okay, all right, thank you very much.
Have a good
All right.
day.
What do they have in store for us today? I don't know. We'll see right now. We're about to find out.
Today is Tuesday, April 7th, 2026. This is a hearing being conducted via video at the BOPP Central Office in Robinson Correctional Institution. Can you please state your name and DOC inmate number for the record?
Can you guys see?
David Garceau, 264063.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is Attorney Matthews and P.O. Kwasnick. Can you please identify yourselves for the record?
Good morning, Peter Matthews with the Public Defender's Office for Mr. Garceau.
And Dennis Kwasnick, Parole Officer to Department of Correction, Parole and Community Services.
All
Thank
right,
you.
there we go.
The purpose of this revocation hearing, this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by the preponderance of evidence. That is, the better or weightier evidence that must establish that. More probability than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded.
And streamed live and direct out of my basement. What up,
Testimony
Carson?
at today's hearing will be taken under oath. Inmate Garceau and Parole Officer Kwasnick, please raise your right hand. You solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth.
Hey, what up, Rosie?
So help you God, or upon felony or perjury.
I do.
I do.
He does.
So I'm going to go over the procedure of the hearing. First, I will read you your rights. Then we will review the parole violation charges that the state, your parole officer, is bringing against you. Then I will review and identify exhibits filed for the record. The state will have an opportunity to present all relevant testimony subject to cross-examination and any relevant documents. After the state is finished, you will have the same opportunity. After considering all of the evidence presented, I will announce my findings.
Hey, what's up, Pisky Elf?
If I find that you violate one or more of the conditions of your parole, the state will have an opportunity to speak on your background and history. After the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure before we begin?
No, I do not.
Okay. So we're going to go over your rights. You have the right to be represented by an attorney at this hearing, and counsel is present. You have the right to receive written notice of charges of violation. Did you receive written notice?
Yes, I did.
Do you have the right to review the evidence against you before this hearing? You have the right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes, I do.
So we're going to go over the charges. We will now review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. P.O. Kwasnick, can you please read the violation details?
Charge 1 is reporting. You have demonstrated a repetitive pattern of non-compliance regarding reporting instructions. Between May 12th, 2025 and November 10th, 2025, you failed to report on at least 14 separate occasions. The dates you failed to report are 5/12/2025, 5/13/25, 6/2, 6/16, 6/17, 7/1, 9/15, 10/6, 10/27, 10/28, 10/29, 10/30, 10/31, and 11/10/2025. Charge 2 is curfew on November 16th, 2025 at 12:31 a.m. the Winchester Police Department conducted a motor vehicle stop involving Mr. Garceau. Although your GPS unit was malfunctioning at the time, the timestamp of the traffic stop indicates a violation of the curfew established in your GPS agreement of 9 p.m. until 6 a.m. Charge 3, program participation. On 10/31/2025, you admitted to using cocaine and were instructed to engage in a substance abuse treatment program for an evaluation. As of 11/12/2025, you failed to participate in the program as instructed. Obey all laws is charge number 4. There are 5 subsects or 5 sections of this. Section 1. On 4/25/2025, you traveled to Florida and received a citation for improper lane change. Number 2, on 7/6/2025, the Winstead Police Department investigated a larceny in which a victim paid you $1,700 to paint her residence. You failed to perform the work after approximately 1 month. When the victim demanded her money back, you stopped responding. Police spoke to you and you agreed to return the money by July 11, 2025. However, as of July 14, 2025, you did not refund the money, and the warrant was issued for 53A-125, larceny in the 4th degree as a result. Furthermore, on 11/17/2025, you failed to show up to court for the aforementioned offense, and a rearrest warrant was issued.
Connecticut.
Number 3, on 7/11/2025, I, Parole Officer Kwasnick, was notified by the Watertown Police Department that an arrest warrant for Mr. Garceau would be submitted after a woman paid him $400 for work that he never performed. You took the money and the victim was unable to contact you. Waterbury PD reported that they reached out to you, but you were elusive.
Who pays before they get the work done?
Watertown PD.
You're going to pay my house. I'm not going to pay you till after you're done.
6th degree, but would not be executed as your mother had paid the victim back, and the victim requested the charges be dropped. Your actions of taking $400 and not providing work violated 53A-125B, larceny in the 6th degree.
Like here,
Number
$400.
4, on 11/16/2025
Hell
at
no.
12:31 a.m. The Winchester Police Department conducted a motor vehicle stop of a vehicle that you were operating. You were issued an infraction for Connecticut General Statute 14-218A for speeding. During the investigation, officers determined that you were operating a motor vehicle with a suspended license and issued a verbal warning for operating a motor vehicle with a suspended license, violation of Connecticut General Statute 14-215. You're also required to have an ignition interlock device in any vehicle you operate. The vehicle you were operating was not your vehicle, which is equipped with an interlock device. When I asked Police Officer Green if the vehicle you were operating was equipped with an IID, he stated it was not. Your actions are in violation of Connecticut General
Hey, thank you, yo mama.
14-227K, operation of a motor vehicle without an ignition interlock device or tampering with an interlock device.
What up, Nicole?
Number 5, from 6/19/2025 until November 2025, you operated a motor vehicle hundreds of times with a suspended license in violation of Connecticut General Statute 14-215. Notification of arrest.
P.O. Kwasnick. So there's a no finding of probable cause, which was made on the charge number 5 of notification of arrest by hearing examiner Saunders. So we will not be considering this charge today, but you can continue on to charge 6.
One charge out of the many?
Both, subsections of notification of arrest?
Yes.
Okay.
He's definitely been keeping track of everything. He's been writing everything down on sticky notes.
Charge 6, drugs. On 10/31/2025, Mr. Garceau admitted to using cocaine from 10/27/25 until 10/30/2025 and signed a voluntary admission and misconduct. Charge 7, travel. On 4/25/2025, you traveled to the state of Florida without my knowledge or permission, evidenced by an infraction received there for improper lane change and your own admission. Number 2, on 6/16/2025, you went to the state of Massachusetts without my knowledge or permission. You did not have permission to leave the state. Charge 8, no driving. You only had my permission to drive the vehicle if it had an interlock device, if you had a valid driver's license, and had a legally registered and insured vehicle. Numerous times from 6/19/2025 until November 2025, you operated a motor vehicle with a suspended license in violation of Connecticut General Statute 14215. Furthermore, on 11/16/2025 at 12:31 a.m., the Winchester Police Department conducted a motor vehicle stop of Mr. Garceau. He was issued an infraction for Connecticut General Statute 14-218A for speeding. During the investigation, officers observed that Mr. Garceau was operating a motor vehicle with a suspended license and issued him a verbal warning for operating a motor vehicle with a suspended license. For Connecticut General Statute 14-215, Mr. Garceau is also required to have an ignition interlock device in any vehicle he operates. The vehicle he was operating was not his vehicle, which is equipped with an interlock device.
Okay, so we are, the state has filed the following exhibits that have been marked for identification purposes. Can you please read the exhibits, P.O. Posner?
Yep. Exhibit A, signed conditions of parole. Exhibit B, parole violation report. Exhibit C, notice of parole violation. Exhibit D, remand custody order. Exhibit E, copy of several Connecticut statutes, including 53A-125B, 14-227K, and 14-215. Exhibit F, emails and documents from the Connecticut DMV/collect. Exhibit G, copies of a citation from the state of Florida, case number 2025-121-051-TRCI. Exhibit H, GPS agreement. Exhibit I, Intoxilock report. Exhibit J, Winchester case 25-10250, complaint ticket and description. Exhibit K, judicial branch printout of docket L18A-CR25-0191084-S. Exhibit L, emails from calls plus messages, page and contractor messages. Exhibit N, Winchester case number 25-5409. Exhibit N, prior misconducts. Exhibit O, voluntary drug admissions. Exhibit P, decision information summary. Exhibit Q, text messages between Mr. Garceau and P.O. Klasnick.
This guy's like a one-man crime spree right here. Just doesn't know when to stop.
Addendum?
Hey, Ash, thank you.
Addendum 1, on 3/3/26, Mr. Garceau appeared under docket L18W-CR25-0191084-S and pled guilty to 53A-125, larceny in the fourth degree, and 53A-173, subsection A1, failure to appear in the second degree, and was sentenced to an unconditional discharge on both counts. All criminal cases have been adjudicated, and the revocation hearing can proceed.
Thank you. Attorney Matthews, did you receive the notice of parole violation report, and other documents that I just marked for identification purposes?
I did.
And did you review this information?
Yes.
Okay. The defense has filed the following exhibits, which are marked as follows. Exhibit number 1, list of parole accomplishments and future plans for parole reinstatement. Today, we have no witnesses. Attorney Matthews, do you request that any witnesses be allowed to testify at this hearing?
No, I have no witnesses for today.
At this time, the state will have the opportunity to call any witnesses, present evidence, speak to any evidence submitted. Do you have any witnesses or wish to testify?
I have no witnesses, and I believe parole violation and the evidence submitted speaks to itself.
Okay, thank you. It is now the defense opportunity to call any witnesses, present evidence, and to speak to any evidence submitted. Do you have any witnesses?
With all that larceny he was doing,
I'd like to address the evidence.
no wonder he was able to afford all those trips to Florida.
So I'll start with charge 1 reporting. I did review the evidence that was submitted. I did look at Exhibit Q. I think Exhibit Q does demonstrate that Mr. Garceau did stay in contact with his parole officer.
Hey,
there was
Keza.
some difficulty he had in making these appointments. I do understand that, but for the most part, it seems like he contacted his parole officer. He stayed in touch with him and let him know what was going on with regard to his whereabouts. On charge 3, the program participation, the allegation is there was a missed evaluation on November 12th, 2025. Mr. Garceau, however, he did participate in extensive treatment both before and after this missed evaluation. He engaged in inpatient treatment at Rushford from July 9th until July 28th. He then completed additional inpatient treatment at the app program from November 18th until he was remanded on December 18th, when he was just about done with that program. He also engaged in ILP treatment through MCCA over the course of parole supervision. So while the charge here alleges one missed appointment, I don't think there's sufficient evidence that he failed to adequately participate in substance use treatment programs that were ordered by parole. Charge 4, obedience to the law. The first cited incident on April 25th pertains to a motor vehicle infraction. As that's not a criminal offense, I would argue there should be no finding with regard to that incident. The second incident pertains to the case where he pleaded guilty in court and he did receive an unconditional discharge on larceny for an FTA in the second degree. Mr. Garceau, he did plead guilty under the Alfred Doctrine. He would like the board to know that the complaint was paid back in full. There's not a financial loss here.
His light turned off.
He did intend to complete this work. However, he was instructed to go inpatient on July 9th, and that did cause a lot of disruption with his ability to get this job done. He did want to contest these charges. However, given that he would not be able to receive a parole hearing until the charges were resolved, he did elect to accept a plea agreement for the unconditional discharge in order to resolve the matters. The third noted violation of obedience to law is a similar situation. However, this was not prosecuted in court. And I would argue here that there's insufficient evidence presented to find a violation based upon that incident. Here as well, the work could not be completed as scheduled because he needed to go inpatient on July 9th, which he did do. The money was returned to the client. In order to be convicted of larceny, the state needs to prove more than simply that money was paid and the work was not performed. They need to prove that Mr. Garceau acted with the intent to permanently deprive the complainant of money. Based upon the factual circumstances of this incident and the evidence that's been presented, I would argue the state cannot establish by a preponderance of evidence that he acted with the intent to permanently deprive the client of money. And I would argue there should be no finding with regard to this incident. The fourth alleged violation is that he was operating a motor vehicle without an interlock device. I would just note here that Mr. Garceau was not charged with that offense. He was not given a warning to that offense. The police report makes no mention of anything to do with an IID at all. And the final incident here under obedience to law is that the allegation is that he was operating a motor vehicle while his license was suspended. Again, this appears to be based upon intoxilizer records to show when his car was turned on. Again, I would just know he was never stopped by the police. He was never charged with that. And I think there needs to be more evidence than simply the fact that an intoxilizer is blown into to prove somebody's in violation of operating under suspension. There was no finding on charge 5. I'll skip that. And then charge 6, the drug use. Mr. Garceau did acknowledge that he had some struggles with substance abuse. He did engage in treatment. And after this incident, he did engage in inpatient treatment at the
Trish.
So I understand there were some struggles with drug use, but he was taking a lot of steps to address it. And he's planning on continuing to address that in the future. Charge 7, I'm going to ask Mr. Garceau a few questions here with regard to charge 7. Mr. Garceau, why were you in Massachusetts on June 16th, 2025?
Good question.
My uncle had unexpectedly passed away, and I went with family to the hospital while he was in passing. It was a sudden thing, and I didn't think to call parole at the time that it happened. It was just an instinctual thing, and I had went. But I told my parole officer that I had left the state and gone to Massachusetts for my uncle's death.
Thank you. And why did you travel to Florida on April 25th, 2025?
My son had passed away October 19th of 2024, right after I made parole for this situation. And I went down there to collect his ashes.
Thank you. And finally, did you have conversations with Officer Quadrick about your ability to drive a vehicle?
Yes, I did. When I first came home, my license was suspended for 23 years.
23 years?
They gave me my license back
Big
with
mistake.
the IID in my vehicle, in a vehicle for a year. I went and took my driving test. I obtained my license. I had IID put in my vehicle. And Mr. Kwasnick knew that I had my vehicle with everything legal. It was probably like the second week that I came home that I had all that situated and I was allowed to drive. With the understanding that, you know, I had my license and IID in the vehicle. I went to parole numerous times in my vehicle, which parked right outside of his window. He knew I was driving. He would come to my house. My truck is parked right there. With the suspension, I paroled to my mom's house when I first came home from parole. I transferred my parole to my house. I was working on my relationship with my ex-wife. My mail was not going there, and I did not honestly know that my license was suspended until I got pulled over in November, which was a shock to me because I paid the fine for the improper lane change in Florida, and I didn't know that I had to send the receipt and confirmation of the fine or the ticket paid to the Connecticut DMV because I never received anything.
Wait,
All right,
what?
thank you
thought
very
just
much.
be-
Thank you.
Come again? Can somebody translate that for me?
I heard
I don't
Fred
intend what he
Thank
was trying to convey to us over here.
P.O. Quasic, would you like to make a closing statement before I make my findings?
Sounds like a bunch of horse manure,
yeah.
if you will.
In terms of the reporting, the text messages, you could see, and I think the text messages are provide that. Although Mr. Garceau would update me on his location, he still wouldn't report. It would be right before he's supposed to report and give me excuses like his car was in an accident or he's right around the corner in Harwinton. I would sit at the police department for sometimes 6-7 hours waiting for this guy to report. It was just a pattern of him using drugs, not reporting, trying to gain them into compliance. The program participation, I mean, this was after extensive graduated sanctions that he had to go to Rushford, and missing MCCA after the relapse. I believe that was MCCA.
Hey, thank you, Linda.
That's why he had to go to the App Foundation. This was a graduated sanction because he just was not participating into the programs. The criminal offense, going to the July 9th inpatient, of the intent to defraud.
What I want to know is what he has on that paper right there. What's on that paper?
With the other one, I understand I don't have the old warrant. It was signed, but the GA-18 decided not to prosecute it because the victim said, I don't want to prosecute anymore. It does not mean a crime did not occur. The IID for charge 4, I mean,
Doodles
stated this. So despite his license being suspended since June 2025, those interlock reports indicate that he operated the motor vehicle hundreds of times while it was suspended. It was suspended because he went to Florida without my authorization or
the
knowledge,
next coca order.
Received a motor vehicle infraction, which is violating the law. That's why he was issued an infraction, which resulted in his license being suspended because they were sending him notices, which he didn't pay. So the DMV suspended it. All that documentation is included for the DMV and the collect printouts showing that his license was indeed suspended. The Intoxilock reports show that he did start the vehicle. He admitted that he is the only one that drives this truck. Let's see. November 16th, Mr. Garceau was stopped driving that vehicle that was not equipped with his required interlock device.
Damn,
so
son,
under
where'd you
Connecticut
find
law,
this?
operating the vehicle without the required interlock device is a serious offense. It carries at least a mandatory period of mandatory minimum of a year. The reason Winstead PD did not arrest him for that citation, they didn't click on the collect
call?
terminal, the screen to show that it was required, that the IID was required. So consequently, the officer only submitted the speeding infraction.
Smoke
and the
weed
verbal
every
warning
day.
was issued for driving with a suspended license rather than the appropriate criminal charges. We had conversations with GA18. The prosecutors were willing to prosecute the interlock in the license violations. However, because Mr. Garceau immediately pled guilty for that speeding infraction and mailed it in, the case was considered in motion, preventing the state from adding more serious charges to that of the specific incident of driving without an interlock device.
Hey, Tracy, thank you.
Drug use, I mean, the misconduct speak for themselves. The travel pass, I understand for family issues, this would have not been a problem. I would have submitted it. More than likely, he would have been approved. I can't see a reason he would not be approved to go down to get his son's ashes. However, his parole conditions are very clear. He's been violated in the past for going to different states when he's on parole, when he's supposed to be requesting these travel passes. This is not new. He knows he's on parole. He's supposed to request a travel pass. And it would have been granted, but he chose not to even request it and just go out of state. And then finally, the driving, yes, he was allowed to drive. He showed me the valid license, registration, and insurance. However, when DMV is mailing you letters saying it's suspended, and I spoke with DMV and they said the letters went out and so on and so forth, he was notified that the license is suspended. They're not notifying me because they don't know he's on parole. So ultimately, he did break the law. He was driving. He was allowed to drive by me, yes, while it was a valid license, registration, and insurance. But as soon as his license was suspended, I wouldn't have allowed it. And I told him he has to drive the IID, which he was doing in Winchester at midnight in a different car, circumventing basically the IID and driving a car that wasn't equipped with one. So my response to the concerns addressed by the defense.
Book him, Dano.
I can briefly respond to a few of those points.
Yes. Yes.
So with regard to the program participation, I understand he struggled with drug use, but I just don't think the evidence is there to show that he wasn't participating. Going inpatient twice, doing ILP, doing at MCCA, doing outpatient after that, I think he has demonstrated a willingness to work with these programs and participate in the programs. There's one missed appointment. There may have been other issues he's had with these programs, but what we have in front of us and what the evidence is that he did do, I don't think there's preponderance of evidence that he did not participate in these programs. With regard to the charges, yes, I understand a finding can be made based upon the guilty pleas on the second one there. But the third one, which is a similar circumstance, I just don't think the evidence has been submitted to show that he acted with the intent to permanently deprive somebody of money. We don't have the warrant in front of us, and even if there was a warrant in front of us, the state would have to prove that. And based upon the factual circumstances here, I don't know if the factual circumstances were included in the warrant or not, because it's not here. I just don't think that they could establish that in this case. I just wanted to correct one thing about the 227K. The mandatory minimum for that is not a year unless it's a third offense. It's really a 1 year. It's a 30-day mandatory minimum for a first offense of operating without an interlock device. And
they haven't said how long he's been
additionally
in prison for at this time.
Else on that issue. That's what I have to say. Thank you.
Or not that I heard.
Thank you.
Not that I recall, if you will.
I will now take a moment to review this case and will notify you of my findings in a moment. I'm going to take a brief recess and then I will come back to when I make my findings.
A brief recess?
So I'm going to
Come on
go
now.
off the record and I'll be back. Thank you.
The hell? Just let us know what it is right now. You know whether you're gonna violate him or not. But he got enough. He got
just to let you know, we are still connected to the live stream. So if you can just sit there quietly, anything you say would go out to the public.
Yes, ma'am.
Hey, what's up, doctor? How's it going? All right. For anybody that's just joining up right now, this is going to be a board of parole hearing from the state of Connecticut, if you will. I'm going to speed it up. This is from earlier on today. This is not being live streamed, except for me. I am live, but this stream is not. It's from earlier today, if you will. Give me a moment. I'm going to speed it up so we could go ahead and get on with the functions.
an infraction and does not meet the element. Okay, I'm going to make my findings.
All right.
On charge number 1, condition of reporting, in regards to the dates of 9/15/2025 and 10/31/2025, a no finding was made at the preliminary hearing by hearing examiner Saunders, and therefore we will not be considering them at the revocation proceedings today. The remainder of charge number 1, I find that you violate condition of reporting based on the evidence presented in State's Exhibits A, B, N, and Q. On charge number 2, I find that you violate condition of curfew based on the evidence presented in State's Exhibits A, B, H, and J. On charge number 3, I find you violated the condition of program participation based on the evidence provided in State's Exhibits A, B, N, and Q. On charge number 4, condition of obedience to the law in regards to parts 1, 3, and 5, a no finding was made at the preliminary hearing by hearing examiner Saunders, and therefore we will not be considering them at this revocation proceedings today. Regarding part 4 of charge number 4, a no finding is entered on Connecticut General Statute
What up, MX?
13-218A, speeding as it is an infraction and does not meet the elements of this charge.
That's right, Jenna.
A no finding is also entered on Connecticut General Statute 14-227K, operation of a motor vehicle without an ignition interlocking device or tampering with an interlock device. As Exhibit F indicates that Mr. Grosseau did not have the right to operate a motor vehicle on 6/19/25 due to a suspended license. Therefore, the elements of this charge were not met by the state. For the remainder of charge number 4, I find that you violated the condition of obedience to the law based on your conviction for failure to appear second and larceny fourth on 3/3/26, for which you received an unconditional discharge. In addition, the evidence provided in support of the charge are State Exhibits A, B, F, J, K, and F. On charge number 5, conditions of notification of arrest, a no finding of probable cause was made for this charge by hearing examiner Saunders, and we will not be considering this charge today. On charge number 6, I find that you violated the conditions of drugs based on the evidence presented in State's Exhibits A, B, N, and Q. On charge number 7, I find that you violate condition of travel based on the evidence presented in State's Exhibits A, B, G, N, and Q.
What up,
And on
Melissa?
charge number 8, I find that you violated condition of no driving based on evidence presented in State's Exhibits A, B, F, and J. That concludes the fact-finding portion of this hearing. Before I make my recommendations, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. The purpose of this part of the revocation hearing is to help determine what outcome I will recommend. Parole Officer Kwasnick, do you wish to make a statement regarding Mr. Grosseau's violation, background, history, and history at this time?
Yes. Despite receiving extensive graduated sanctions, Mr. Grosseau demonstrated a persistent disregard for the conditions of his supervision. According to the DIS, which I submitted for evidence, he has 24 prior convictions and also
24
previous community supervision failures. This would be the 21st community supervision failure.
21st?
He has been afforded every possible tool to maintain his liberty. Multiple referrals to drug treatment programs. He struggled with addiction while he was out. He did not report.
At this point, what didn't he do?
Permission, convicted of new crimes. So again, he chose to continue.
So he's been to prison
use
21
cocaine,
times.
Citizens operating motor vehicles illegally while bypassing the safety devices. Reinstating his parole would be incompatible with the welfare of society. He has 3 months to go. The state thinks that the final 3-month period of incarceration is the minimum necessary sanction to ensure public safety. Again, I have serious concerns with the motor vehicle and legal violations. His specific disregard for those motor vehicle laws and specific parole safety restrictions represents a severe threat to community safety. He was bypassing safety devices, the EIID, driving under suspension. And then finally, Mr. Grosseau is on parole for a violation of probation.
I can't wait for him to start reading those notes or that letter he got right there in his lap.
Let's see if the DIS says approached a driver on the side door while holding a folding knife and demanding money. He then, I believe, was violated when he was on TS for that, went on probation. And what probation, the VOP warrant says, according to the DIS, is exactly why he's here, again, with parole. He has substance abuse evaluations. He didn't go to them, follow up with any treatment deemed appropriate in the standard conditions of probation. He didn't report when the parole officer or probation officer was telling him. He didn't tell the probation officer immediately if he was arrested. He didn't submit to medical or psychological examinations, urinalysis, alcohol, drug testing, and or counseling sessions. And also, should be noted, the new arrests while he was on probation, again, was the same behavior he pled guilty to, which was taking money as a contractor for $600 of materials and never doing the work. Police were able to seize copies of the text messages between the victim and Mr. Garceau, which corroborated the victim's versions of events. So the office also observed and seized a copy of a successful transaction. So this was all in the DIS. So basically the same criminal behavior that has landed his violation of parole is the same reasons that his probation was violated. So with that, I'm glad that Mr. Garceau is in tier 4, which I read in his, his exhibits. He has a bad substance abuse problem that he needs to address, but the state would not feel comfortable giving him the last 90 days back out in the community.
Thank you. Attorney Matthews, do you wish to make a statement regarding the violation background or history at this time?
Yes, thank you. So Mr. Garceau, he is 46 years old. He was born and raised with his family
46?
here in Connecticut. He does indicate he has a strong support system here in Connecticut.
What up,
with
Lonnie?
His mother, his sisters, his aunts, and his children. He has a good relationship with his family.
How
When
embarrassing.
he's released, he is looking to be sponsored by his mother, who resides in Torrington. And he'd be seeking a halfway house in the Torrington area as a backup option if that sponsorship is not possible. He has supported himself. He is working, painting and remodeling. He's been doing that for some time now.
Painting and
When
remodeling.
he's released, he is planning on joining the Painters Union.
Painters
I
Union?
understand what
up, G?
Officer Klosnick is saying with regard to these convictions that we received for larceny 4, but I do think there were some extenuating circumstances there. Even just reading the evidence here, he was supposed to pay his money back by July 14th, and he went impatient a few days before that. He has to go impatient. He doesn't have a whole lot of options. When parole tells him to go impatient, he has to go impatient. I do think there are some extenuating facts here with regard to what happened. And I would also note that these individuals were paid back all that money that was taken for him to complete this work. He has indicated, as I indicated, he's looking to join the Painters Union. He's been in touch with them already, and he is confident he'll be able to have employment through the union when he is released.
I don't think so.
He has completed his GED while he's been incarcerated. In addition to painting, he's worked construction at several different companies in the past. He's working now during his remand as a dorm janitor. He's been doing that. I do think he's worked with parole. I disagree with the conclusion that he was not working with parole and not engaging in treatment. He was engaged in a lot of treatment, as I indicated.
In
He
his
went
dreams.
He did relapse. I understand that. He's apologetic about that. And he has struggled, but I do think he was making a lot of efforts to work with parole and engage in the treatment. He was inpatient
Right, Kyle?
at Rushford for 30 days. He was inpatient at the App Foundation at 30 days. I also think it's noteworthy that he was remanded December 18th. At the time he was remanded, he had been inpatient for the past 30 days at the App Foundation, doing very well by all accounts. He was just about done with that program. So there were some problems earlier, but at the time of his remand, I think he's demonstrated an ability and willingness to work with parole and engage with the treatment that he does need. When he's released, he's going to continue with his substance abuse treatment. As he indicated, he's been involved in tier 4. He's doing well. He does know he needs to engage in substance abuse treatment going forward. He also wants to engage in some sort of grief counseling, which he thinks may assist him in maintaining his sobriety by addressing some of the triggers for his relapse that he's been dealing with since the death of his son. So he is on parole, and it looks like, I believe, until August So it's a little more than 3 months left. He's been incarcerated now for some time, I think since before Christmas.
So like
I
like
would
3
ask
months.
him to be released at the next available date. And
Going
I
on
think he could
4.
benefit from having these last few months of supervision and transition rather than just spending it incarcerated and then coming out with no sort of supervision whatsoever. I don't feel that his conduct on parole has demonstrated an inability to work with parole or benefit from further supervision. He knows he needs to address the license situation going forward. That was a surprise to him when he found out that suspension had taken place. He needs to get that addressed. With regard to the IID, unless I misheard for the findings, my understanding is there was a no finding on the operating without an IID. So I would ask that not be taken into consideration at this time. He does want to get back to his family. He wants to get back to work. He wants to address his substance abuse issues, which he understands is going to be a lifelong project. Mr. Garceau, is there anything I didn't address that you'd like to say at this time?
No, I think you pretty much summed everything up. Just that.
It's about time he moved, turned on the light.
I didn't expect life to be so hard without my son. And I relapsed because of it many times. In regards to the license, I wouldn't have driven. I would have taken care of it. It was a simple ticket. And I could have taken care of that if I knew, if I had received mail about the situation. Like I said, it was a simple improper lane change ticket. There was no malice on my part. I didn't intentionally not respond to it or not take care of it because that's my license. That's my livelihood. I didn't have my license in a long time, and it was an accomplishment to me to get it back. So being suspended, it was a shock to me when I found out that my license was suspended.
Is he gonna cry? We got a crier on our hands.
And with the larceny charge, I didn't agree with being charged with it, so I pled under the Alpha Doctrine, and at the end, I thought the charges were going to be dismissed, and I wasn't going to be charged with them, but I was misinformed by the public defender. When that happened, I was in the parole office with Kwasnick, and he told me that I need to go to rehab. At that time, I told Kwasnick that I have 2 jobs going, one in Watertown and one in Winstead, and that I if I could possibly get a week or 2 weeks to do them. So
all this running around is getting me hungry.
Giving me money already. He said, no, you got to go to treatment now. Take care of it when you get back. And this is where these charges stem from. The morning I got out of Rushford, I knew I had a warrant. As soon as I found out I had a warrant, I called my mother. My mother has access to my money. She went and took $2,000 out of the bank for me and went and repaid the ladies for me because I couldn't have no contact with them because I was in the program. This happened 2 days before I was released from the program. My tools were on the job. I had thousands of dollars in tools on the job. I didn't leave with intention to take these ladies' money. I had the money in the bank. I was doing, despite my relapses, I was doing pretty good as far as the work.
Pretty good.
And there was no intention on taking money. I put myself in a situation to be taken away from the job by relapsing, and Kwasnick had to do what he had to do, and I respect him for it. He's tried to help me numerous times.
Yeah.
And like I said, the death of my son it's been weighing hard on me.
Hey, I could imagine that has to be hard.
2 weeks after I got here, I wrote the same week I got here to get into it. It wasn't a stipulation. It's something I need for myself.
Hey, Steph, thank you.
I've been dealing with addiction most, a long time in my life, and I'm tired. I'm tired of it.
Tired of being tired?
So the first time in my life, I've come to jail and I've utilized what they have here. And it's
First
made a big
time.
difference to me. As far as being able to express my feelings and to talk to somebody and to get out what's on my chest instead of holding it in until I ultimately relapse, because I don't want to feel feelings anymore. I know when I do get out, if I am granted parole back or I have to discharge, I know that I have to continue with recovery. I know that I have to attend AA or NA meetings, which I never really have unless I was told to. But I know today that's something that I desperately need in order to stay sober and to live a happy life. My mother just had surgery, a 7.5-hour surgery, and she just came home from the rehab yesterday, and she needs her son home because she has nobody else. My kids need me home.
For what? You're going to be hitting the pookie.
Hey, Daddy, when are you coming home? By my 8-year-old son. And it hurts. Yeah, I have an addiction problem, but I'm doing my best. I feel for the first time in my life, working towards my recovery. And I want to continue that when I come home. And if I'm granted parole, I take any stipulations to reintegrate back into society, whatever it may be, a bracelet, anything.
It don't sound like it from his prior actions.
A little bit of time with
driving out of state
to get my
2 times. I'm sure there's more than that.
Society, and to show that
driving without an interlock.
Best foot forward and do what I need to do. And with that,
hitting the pookie.
I think I'm all set.
Thank you, Mr. Garceau.
Thank you.
Thank you.
I mean, I feel
Any
bad for him losing
further
his kid,
comments,
but
P.O. Klosnick or Attorney Matthews?
it's like, take some responsibility of your life.
No, just the dates I
46
have.
years
It
old.
was July 11th that he was given the opportunity to give that money back. And they're saying that he went into Rushford on July 14th, 3 days later. So, and the police officer, when I spoke to him, both of them said they gave him multiple opportunities to repay it. And then he's just stopped contacting him. But
I don't think that I think you went in July 9th, not the 14th.
I don't know. And it was July 9th. I don't have.
I could imagine losing a kid is difficult
Attorney
and tough.
Matthews, anything? Oh, are you all set? P.O. Klosnick?
Yeah.
Anything else?
Nothing else to add.
But then at what point do you stop using that as an excuse to get high and break all these other rules?
Okay. For a halfway house, or
Don't drop the
what's your
soap.
mother's address? Sorry, where would you like to go? Or
The same address that I paroled to in Torrington, which is the 170 Scoville Street, Torrington, Connecticut.
You say that again, that street again?
I think it's listed in our report.
bullshit,
If you look at the future plans for the Stevens housing section, it has the sponsor address, name, and phone number.
Okay. Thank you, Attorney Matthews. All right, and then halfway house, where would you like to go with that? Is
I mean,
play?
the water barrier Torrington area, anywhere where it's close to my mother, because like I said, she just came home yesterday from rehab, from having a 7.5-hour back and neck surgery, and she's not able to do much for herself, and she's the only one. She lives by herself, so my help would, she really needs help.
They probably gave her
I'd love to be there for her.
an in-house nurse, being that age, especially since she doesn't have anybody.
So
because obviously he's not reliable.
I reviewed all the evidence provided. Based on that, I recommend that your parole be revoked with no new re-parole date. That is an approximate 7-month period of confinement as a sanction And that will bring you to your end of your sentence, which your end of your sentence now is 7/23/26. In the event the board lessens my recommendation, my recommended sanction, the following conditions are recommended: mental health evaluation and treatment deemed as necessary, strict no driving, a halfway house. My findings and recommendations will be forwarded to the board on April 16th, 2026. You should receive the official written decision from the board within a week from that date. The board may lessen the recommended sanction, let my recommended sanction stand. This concludes the revocation hearing, and I am going off the record.
About
Just one
time.
more time, what was the board meeting date?
4/16.
I definitely wouldn't put him down as an emergency
That's it.
contact for any type of
You're all
emergency.
set, Mr. Grosso.
Thank you.
All right, good luck, Dave.
Thank you.
Vayas con Dios. Anyhow, hey guys, I'm gonna take a break, but if you guys want to continue watching, I am gonna leave the stream running on my YT account. You might be wondering what's YT. You know that little red logo with the white triangle. It's also the same name, collect call from. If you type that up, you'll find the stream. I do have two streams going on. I have Maricopa that has a blank screen, and then I'll have this one here, which would be the Connecticut Board of Parole hearings. I gotta go ahead and stretch my legs. I've been on here for about 2.5 hours. I gotta go ahead and get my blood circulating on my legs and whatnot, because back in December I ended up having a blood clot, and then I am on blood thinners right now. So I want to stretch my legs, and I want to get something to eat and hang out a bit before my daughter gets out of school. We're gonna go see Super Mario Galaxy movie today, so. She's been asking for the last few days.
Good morning.
Morning. You guys ready?
Yes. Do you have?
I have house kids right now.
Hey, but I do appreciate you guys.
Thank you. You can send them in.
All right. And like I said, if you guys want to continue watching, jump on over to YT, collect call from. All right. I highly appreciate you. If you guys haven't done so, please do so. Hit that follow button. It's free 99. It doesn't cost you a thing. It's like breathing air. Hitting the follow, dropping a comment, and jumping on over to my other platform. All of that will definitely help me out. We're about to be hitting 30,000 followers on the American account. On the British account, we're about to hit 24,000. So, we're definitely growing. Damn, they got this for an orange. Oh, this one looks like he might be a little spicy, if you will. Oh, yes. He's definitely not playing with a full deck of cards, if you catch my drift. The elevator's not going all the way up.
How you doing?
He might be a few French fries short of a Happy Meal. I might end up sticking around for this one. Looks like he might get up and throw the chair, if you will. I don't know. What do you think? No, I'm just playing. I'm not going to stick around. I got to go. I got to go.
With you in a sec, okay?
But I do appreciate you guys, all right? Come on over to the other platform. All right, guys. For you guys that came on over to YT, I appreciate you guys. To YouTube. Let me see here.
I am Parole Officer Menard, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Jay Hotchkiss, inmate number 283-733. Today is April 7th, 2026. This hearing is being conducted via video at the BOP Central Office and Hartford Correctional Center. Can you please state your name and full name and DOC inmate number for the record?
Yes, Jay Hotchkiss, 283-733.
Thank you. This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is Attorney Dean.
Yes, good morning. Hannah Dean on behalf of Mr. Hotchkiss.
And P.O. Richardson.
Hi, good morning, Officer Richardson, Hartford District Mental Health Unit.
Thank you. This is a preliminary hearing which has three purposes under Connecticut law. To determine if there's a probable cause to believe you committed an act that violated the conditions of your parole. B, to determine if the act is sufficiently serious to warrant the revocation of your parole. And C, to determine if you should be held in prison pending further proceedings. The state, not you, has the responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. The testimony at today's hearing will be taken under oath. Mr. Hotchkiss and Parole Officer Richardson, can you please raise your right hand? You solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes, I do.
Yes, I do.
Thank you. The procedure for the hearing: first, I will read your rights. Then we will review the parole violation charges that the state, your parole officer, is bringing against you. Then I will review and identify exhibits filed for the record. The state will have an opportunity to address the issue of probable cause and the severity of the allegations. After the state is finished, you will have the same opportunity. At the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No, I don't.
All right, we're going to go over your rights. You have important rights at this hearing, which I will now review with you. You have the right to an attorney, and Attorney Dean is present here today. You have the right to receive written notice of charges of violation. Did you receive written notice?
Yes.
And you have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
Okay. Now we're going to go over the charges. We will now review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. P.O. Richardson, can you read charge number 1?
Charge number 1, excuse me, under GPS. On 3/9/26, you were placed on GPS monitoring and signed a GPS monitoring agreement, agreeing to abide by the rules of the GPS monitoring device. On 3/10/26, you removed the GPS device off your ankle. This is a violation of your signed GPS monitoring agreement. Specifically, I will remain on GPS monitoring for a length of time determined by a parole officer and will not remove the GPS tracking device or strap from my ankle without prior permission from a parole officer. Charge number 2, residence. On 2/26/26, you were placed at the Stein Halfway House in Hartford. This was your only parole-approved address, and at no time did you have permission to stay at any other residence. On 3/10/26, you left the Stein Halfway House to receive emergency medical treatment at St. Francis Hospital. After leaving the hospital, you did not return to the Stein House. You were unsuccessfully discharged and removed from the bed count on 3/11/26. Charge number 3, absconder. On 3/10/26, you left the Stein Halfway House to receive emergency medical treatment at St. Francis Hospital. Halfway House staff conducted a spot check at the hospital and were informed that you were not there. At approximately 3:38 p.m., you removed the GPS monitoring device from your ankle in a deliberate attempt to evade parole supervision and effectively cutting off all communication with your parole officer. You did not return to the Stein Halfway House at all and were unsuccessfully discharged from their program on 3/11/26. Charge number 4, drugs. On 3/6/26, you used cocaine and oxycodone as evidenced by your signed voluntary admission and positive toxicology test. Charge number 5, halfway house placement. On 2/26/26, you were placed at the Stein Halfway House in Hartford and signed a halfway house agreement, agreeing to abide by the rules of the halfway house. On 3/6/26, you left the Stein Halfway House on a treatment pass to go to an appointment at the village. You were to return to the halfway house at approximately 3:30 p.m., and you did not. It was confirmed that you did not attend your appointment at the village. You did not return to the Stein House until 4:50 p.m. on 3/7/26. At no time did you have permission from either halfway house staff or your parole officer to go to any other location than the village. You also had no prior permission from your parole officer to stay anywhere except for Stein House overnight. Upon arrival, you submitted a breathalyzer that rendered a .017 BAC, as well as providing a discharge paperwork that you had obtained emergency medical treatment that day for alcohol intoxication. This is a violation of your signed halfway house agreement. Specifically, I will only go to the locations indicated on an approved community pass unless changes have been authorized by staff. I will return to the halfway house for my community pass at my scheduled return time. If I am unable to do so, I will call program staff to explain why I may expect it to be late to receive a new return time, and I will not consume or possess alcohol in the halfway house. On 3/10/26, you left the Stein halfway house to receive emergency medical treatment at St. Francis Hospital. Halfway house staff conducted a spot check at the hospital and were informed that you were not there. You did not return to the Stein halfway house at all and were unsuccessfully discharged from their program on 3/11/26.
Thank you. The state has filed the following exhibits pre-marked for identification purposes. P.O. Richardson, could you please read the exhibits?
Sure. Exhibit A, signed conditions of parole. Exhibit B, remand to actual custody. Exhibit C, notice of parole violation. Exhibit D, parole violation report. Exhibit E, signed halfway house agreement. Exhibit F, incident reports. Exhibit G, toxicology lab report. Exhibit H, Hartford Healthcare after visit summaries. Exhibit I, voluntary admission form. Exhibit J, signed offender misconducts. Exhibit K, signed GPS monitoring agreement. Exhibit L, offender violation notice. Exhibit M, Allied Universal Event History and Maps. Exhibit N, Discharge Plan Report. Exhibit O, Board of Pardons and Parole Decision Information Summary. Exhibit P, Board of Pardons and Parole Revocation Summaries.
Thank you. I'm going to relabel Exhibit F into two parts with the incident report on 3/6/26 and the incident report on 3/10/26. I'm also going to relabel Exhibit H, Hartford Healthcare After Visit Summary on 3/7/26 and 3/20/26. Attorney Dean, did you receive the notice of parole violation report, and the other documents I just marked for identification purposes?
Yes, we have.
Right, and were you able to review this information?
Yes, I have. Thank you.
And no defense exhibits have been filed by the parolee or parolee's counsel. Attorney Dean, did you need to continue this hearing to obtain any evidence?
Not at this time.
And today we have no witnesses. Attorney Dean, did you request any witnesses to be allowed to testify at this hearing?
Not today. Thank you.
Okay. At this time, the state will have an opportunity to make a short statement, call any witnesses, and testify with respect to probable cause and the severity of the allegations.
I don't have any additional comments to make in regards to the charges specifically themselves. However, the state would just like to note that this is Mr. Hotchkiss's third violation of discretionary parole within a 2-year time period. The first violation occurred after 4 months in the community. The second violation occurred after 6 weeks in the community. And this third violation occurred after only 12 days in the community. Mr. Hotchkiss was only in the community for 8 days when he left the halfway house for over 24-hour period of time, where his whereabouts were unknown. We did try to work with him, giving him another chance, trying to put him on GPS, referring him to a relapse prevention program. However, unfortunately, he was never able to make that appointment because 4 days later, his GPS he cut off and was completely unaccountable in the community. I would also like to note for the record that Mr. Hotchkiss's non-compliant behavior is not just in the community. Since his return to custody, he has received 3 Class A disciplinary reports, 1 for contraband Class A, 1 for interfering with safety and security, and 1 for an attempted assault on a DOC employee. So 3 very serious DRs, which we would like to note on the record, in addition to the violation that we're here for today.
Thank you. It is now the defense's opportunity to respond, to make a short statement, calling witnesses and testify with respect to probable cause and the severity of the allegations.
Yes, thank you. I will just note this was an unfortunate situation. My client does, I think, self-admittedly suffer and struggle with addiction. And while in the community, he did unfortunately experience a relapse. However, going forward, he does feel very strongly that inpatient treatment at a higher level of care would be beneficial and a good support for him. He has previously, I believe, engaged in that type of treatment a few years ago and believes that that would be helpful going forward once he's released back on parole. I would also argue the allegations here are not serious enough to warrant revocation of my client's parole and his continued incarceration. As to the tickets, I will speak with my client concerning those. I unfortunately don't have copies of those at this time. However, I will just note in the narrative section where it references the situation at the hospital and the situation when he was returned to custody. I will just note that my understanding is at that time he was seen at the hospital for intoxication. So I don't think that he was in his right state of mind when that situation transpired. But those are my comments. Thank you very much.
Gil Richardson, anything else you would like to add before I announce my findings?
No, not at this time. Thank you.
Attorney Dean, anything else that you would like to?
Nothing further. Thank you.
Thank you. I'm going to take a few moments to go over all the evidence presented as well as the testimony that I heard, and then I will announce my findings. All right, I will now notify you of my findings on probable cause. I make a finding of probable cause on charge number 1, GPS, based on the evidence presented in State's Exhibits A, D, K, L, and M. I make a finding of probable cause on charge number 2, residence, based on the evidence presented in State's Exhibits A, D, N, and F. F incident report on 3/10/26. I make a finding of probable cause on a charge number 3, absconder, based on the evidence presented in State's Exhibits A, D, F, incident report 3/10/26, L, and M. I make a finding of probable cause on charge number 4, drugs, based on the evidence presented in State's Exhibits A, G, and I. I make a partial finding of probable cause on charge number 5, halfway house placement, based on the evidence presented in State's Exhibits A, D, E, F, and N. I make a no finding in regards to the consumption of alcohol due to the insufficient evidence. I find that the acts are serious enough to warrant revocation, and I have also determined that you should be detained while you wait for your revocation hearing. The records office at this facility, as well as your parole officer, will be notified. At the revocation hearing, myself or another hearing examiner will determine if you violate the conditions of your parole. If so, the hearing examiner will make recommendations regarding whether your parole should be revoked and what sanctions should be imposed. That is all.
So Mr. Hotchkiss, I'll set up a call with you, as will my social worker, so that we can prepare prior to your second hearing, okay?
Okay, all right.
All right, I'll talk to you soon. Thank you.
Yes, thank you. I appreciate it.
Thank you.
All right.
You're all set, sir.
All set? Okay, thank you. Appreciate it.
So you have Perez refused to see you guys.
Okay. So he's refusing to come?
Yeah, yep.
All right. Well, we will see Addison, please.
Just to confirm, does Perez know that it's for a parole revocation preliminary hearing?
Should I sign off?
Hold on, P.O. Delpane, okay?
Okay.
Thank you. Mr. Addison, can you grab the CO?
Sir?
So does Perez, does he know this is a parole,
I did tell him it was parole, yeah.
Okay, and
did
he's
tell him.
refusing that?
That's correct.
Okay, thank you.
All right.
PO Dilpane, we're gonna do Addison and then we'll address the Mr. Perez, okay?
All right, I'll
Thank
go
you.
back on mute. Thank you.
All right. Good morning. I'm Parole Officer Renard, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Jamar Addison, inmate number 392595. Today is April 7th, 2026. This hearing is being conducted via video at the BOPP Central Office in Hartford Correctional Center. Please state your full name and DOC inmate number for the record.
Jamar Addison, 392595.
Thank you. This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is Attorney Dean
Yes, Hannah Dean on behalf of Mr. Addison.
and P.O. Babbage. Can you please identify yourself?
Parole Officer Babbage.
Thank you. This is a preliminary hearing which has three purposes under Connecticut law. One, to determine if there's a probable cause to believe you committed an act that violated the conditions of your parole. B, to determine if the act is sufficiently serious enough to warrant the revocation of your parole. And C, to determine if you should be held in prison pending further proceedings. The state, not you, has the responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. The testimony at today's hearing will be taken under oath. Mr. Addison and P.O. Babbage, please raise your right hands. You solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon felony of perjury?
I do.
I swear.
Thank you. The procedure for the hearing: first, I will read your rights. Then we will review the parole violation charges that the state, your parole officer, is bringing against you. Then I will review and identify exhibits filed for the record. The state will have an opportunity to address the issue of probable cause and the severity of the allegations. After the state is finished, you will have the same opportunity. At the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No, sir.
We're going to go over your rights. You have the important rights at this hearing, which I will now review. You have the right to be represented by an attorney at this hearing, and Attorney Dean is present today. You have the right to receive written notice of charges of violation. Did you receive written notice?
Yes.
You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses, to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes, sir.
All right, we're going to go over your charges. We will now review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. P.O. Babbage, can you please read charge number 1?
Yes, charge number 1, halfway house placement. On 3/5/26, you signed out a Stein halfway house at 9 p.m. on a work pass with a return time of 9 a.m. on 3/6/26. At 9:15 a.m., you had not returned or contacted the halfway house. Program staff called you on your registered cell phone and you stated that you were 10 minutes away. You were given a new return time of 9:30 a.m. At 10:03 a.m., you had failed to return and all calls to your registered cell phone went straight to voicemail. You returned to Steinhouse at 5:15 p.m. and stated that you were having issues with your child's mother and had spent the day in, quote, Bum Park. You were unaccountable for approximately 7 hours and 45 minutes. This is a violation of your halfway house agreement, which states, I will only go to locations indicated on an approved community pass unless changes have been authorized by staff, and I will return to the halfway house from my community pass at my scheduled return time. If I am unable to do so, I will call program staff to explain why I'm expected to be late and to receive a new return time. On 3/6/26, you signed out of Steinhouse at 10 p.m. on a work pass with a return time of 9 a.m. on 3/7/26. By 11 a.m., you had not returned or contacted the halfway house. Staff were unable to reach you on your registered cell phone, and your employer confirmed that you had not been at work the night before. Your whereabouts in the community were unknown until you turned yourself in to P.O. Babbage at Hartford Parole at approximately 10 a.m. on 3/17/26, approximately 10 days and 12 hours. This is a violation of your halfway house agreement, which states, I will only go to locations indicated on approved community pass unless changes have been authorized by staff, and I will return to the halfway house from my community pass at my scheduled return time. If I am unable to do so, I will call program staff to explain why I'm expected to be late and to receive a new return time.
Thank you. The state has filed the following exhibits pre-marked for identification purposes. P.O. Babbage, can you please read the exhibits?
Yes. Exhibit A, parole conditions. Exhibit B, parole violation report. Exhibit C, notice of parole violation. Exhibit D, notice of parolee rights. Exhibit E, decision information summary. Exhibit F, remand to actual custody order. Exhibit G, halfway house agreement. Exhibit H, parole conditions. Exhibit I, halfway house agreement. Exhibit J, revocation hearing summary from 3/14/23. K, revocation hearing summary from 5/17/24. L, revocation hearing summary from 5/6/25. M, Steinhouse IR from 3/6/26. N, Steinhouse absconder IR from 3/7/26.
Thank you. Attorney Dean, did you receive the notice of parole violation report and the other documents I just marked for identification purposes?
We have, we didn't receive Exhibit O, but I didn't hear it just listed, so we should be all set.
Okay, thank you. And were you able to review this information?
Yes, thank you.
No defense exhibits have been filed by the Parolees Council. Attorney Dean, do you need to continue this hearing to obtain or submit any evidence?
No, not at this time.
Today we have no witnesses. Attorney Dean, do you request that any witnesses be allowed to testify at this hearing?
Not for today's hearing, no.
Thank you. At this time, the state will have the opportunity to make a short statement, call any witnesses, and testify with respect to probable cause and the severity of the allegations.
I just wanted to reiterate for the record that, so I was there that Friday night when Jamar returned. I had actually reached out to him and to his sister, who was able to convince him to come back. He came back. He had been at work that day. We talked about what had happened and his struggle with his child's mother. He asked for permission to go to work that night so that he didn't lose his job. And because he had been at work the night before, I allowed him to go out to work that Friday night. And then Saturday morning, he failed to return, and it was learned that he did not return, did not work. This is not his first time absconding. However, I'm only recommending a 6-month sanction this time because it is the first time that he did reach out to parole and turn himself in. And he did, in fact, report to Hartford Parole as directed and turned himself into custody to me.
Thank you. Sorry. Attorney Dean, let me find my place. It's now the defense opportunity to respond, to make a short statement, calling witnesses, and testify with respect to probable cause and the severity of the allegations.
Yes, thank you very much. And thank you, P.O. Babich, for putting that on the record that he did turn himself in. I would argue the allegations are not serious enough to warrant revoking my client's parole. He was working well in the community. He was employed through On Track in East Hartford and reports doing his groups through CRT in Hartford. And previous to that, he was doing them through Wellmore in Waterbury. It appears that he didn't have any conduct issues while at the halfway house. And my understanding is he was good with his urinalysis. I believe those were consistently negative. And he was, I think, on the list to receive REACH housing through that program. I do believe that this situation was precipitated by my client, being unable to see his child, which I know was very difficult for him, and also being somewhat fearful of others in the community due to his prior charges. But I do, again, think it is relevant that he did do the right thing. He did turn himself in. And so I did just want to note that he, was willing to own up and take responsibility for this situation. Thank you.
Thank you. P.O. Babich, do you have anything else that you would like to say before I announce my findings?
Yes, I would just like to say that I do think 10 days of unaccountability in the community does warrant further incarceration. I struggled with the recommendation and was advised to maybe go a little stronger, and I went with 6 months because he did turn himself in. However, this is, I believe, his 4th time, and he was well aware that Steinhaus was his only parole-approved residence. He absolutely was working. He was sober. He was on the referral list for scattered housing, but he chose to leave, and for 10 days, we don't know where he was and what he was doing, and I do think that's a very serious offense.
Thank you. Attorney Dean, do you have anything else to add?
Nothing further. Shamar, is there anything I didn't include that you want to say right now? I would just say, don't talk about the actual charges, but anything that you want to say that I left out regarding what you were doing in the community? You don't have to, it's up to you. Okay, thank you very much.
Thank you. I'm going to take a few moments to go over all the evidence presented as well as the testimony that I heard, and then I will announce my findings. Okay. I will now notify you of my findings on probable cause. I make a finding of probable cause on charge number 1, halfway house placement, based on the evidence presented in state's exhibits B, H, I, M, N. I find that the act is serious enough to warrant revocation. I have also determined that you should be detained while you wait for your revocation hearing. The records office at this facility, as well as your parole officer, will be notified. At the revocation hearing, myself or another hearing examiner will determine if you violate the conditions of your parole. If so, the hearing examiner will make recommendations regarding whether your parole should be revoked and what sanction or sanctions should be imposed. This concludes the hearing.
Shamar, I'll reach out to you, as will my social worker, before we get our second hearing to discuss everything, okay?
All right.
Thank you. You're all set. Thank you, P.O. Babich.
Thank you. Good luck, Jamar.
Regarding
That was the last
giving-
one, correct?
Yep, I'm just gonna announce, I just gotta make a statement, and then I'll disconnect, okay?
Thank you.
Thank you. P.O. Delpane, I'm gonna make an announcement, and then you should be all set, okay?
Sounds good.
Mr. Paul Perez, inmate number 298262, refused to appear at a preliminary hearing. That is deemed that he has waived his right to preliminary hearing. Mr. Perez has a pending criminal matter and revocation process is continued until the criminal matter is resolved. It should be noted, Mr. Perez, special parole term ends on 5/26/26. Thank you. Thank you, P.O. Delphine.
All right, all set?
Yep,
All right, you have a good day.
you too.
Disconnected out of everything?
Yeah. Thank you.
Perfect, thank you.
Good morning. I am Parole Officer Menard, a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Rashad Bunkley, inmate number 356347. Today is Tuesday, April 7th, 2026. This hearing is being conducted via video at BOPP Central Office in Osborne Correctional Institution. Please state your full name and DOC inmate number for the record.
Rashad Bunkley, 356347.
Thank you. This is a public hearing. Public access to this hearing is available via video live stream. Present this morning are Attorney Dean. Can you please identify yourself for the record?
Yes, Hannah Dean on behalf of Mr. Bunkley.
Thank you. We're going to go over the purpose of the revocation hearing. This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probability than not the allegation is true. If I do not find that there is preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommended revocation, I will make a recommendation as to the appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. The testimony at today's hearing will be taken under oath. Mr. Bunkley, can you please raise your right hand? You solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth. So help you God, or upon penalty of perjury?
Yes.
Thank you. So we're going to go over the procedure of the hearing. First, I will read your rights. Then we will review the parole violation charges that the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. The state is not present today at today's proceedings. However, you will have an opportunity to present any relevant testimony and relevant documents. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, you will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, sir.
Okay, so we're going to go over your rights, the rights of the parolee. You have the right to be represented by an attorney. At this hearing, Attorney Dean is present here today. You have the right to receive written notice of charges of violation. Did you receive written notice?
Yes.
You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
Yes.
Okay. So we're going to go over the charges. We will now review the charges that the state your parole officer is bringing against you and the information underlying each charge. On charge number 1, condition of obedience to the law, the charging officer reported on Friday, November 21st, 2025 at approximately 12:24 a.m. Hartford Police was dispatched on a report of a domestic dispute. Upon Hartford Police Department's arrival, they met with the complainant Jane Doe, known to this parole officer in the Hartford Police Department as Diane Foster, who used to be Diane Porter, 7/14/1984. Diane stated that she texted you and asked if you could stop by the house for a few minutes to talk with her. Diane texted you on 11/20/2025 at 11:30 p.m. On 11/20/2025 at 11:56 p.m., you texted Diane stating you were outside and to open the door. Diane explained to you that you needed to stay here for the night and watch the kids due to having to leave early for work. The kids due to her having to leave early for work. You became upset, refusing to watch the kids. Diane stated you yelled at her, telling her she can't tell you what to do anymore and you are not going to watch the kids. Diane stated as she was about to stand up, you slapped her with an open hand to the left side of the face. You then left her residence running downstairs and out to your vehicle. Diane refused medical attention and the Hartford Police Department did not observe any marks, scratches, or swelling to her face. However, Diane did complain of minor pain. Should be noted, you and Diane have had domestic violence issues in the past. Subsequently, based on the above facts, circumstances, and statements, probable cause exists and a warrant to be issued for the following violations. Connecticut General Statute, Disorderly Conduct, 53A-182, and Connecticut General Statute, Assault. Connecticut General Statute, Assault in the Third Degree, 53A-61 under docket number H14H-CR25-0775024-S. You have a bond amount of $500 and a next court date of 1/27/26 at 10 a.m. at Hartford GA 14. You are currently incarcerated at Hartford Correctional Center and held on remand to actual custody order authorized by a parole supervisor. We're going to identify the exhibits and filings. The state has filed the following exhibits that may have been marked for identification purposes. Exhibit A, signed special parole conditions. Exhibit B, remand to actual custody. Exhibit C, parole violation notice and parolee rights. Exhibit D, parolee violation report. Exhibit E, BOPP decision information summary. Exhibit F, BOPP revocation summary. Exhibit G, arrest warrant, case number 25-027315 from Hartford Police Department. Exhibit H, CT judicial pending case details. In addition, the state's filed an addendum to the parole violation report that states Mr. Bunkley Rashad was charged with Connecticut General Statute 53A-182, disorderly conduct, and Connecticut General Statute assault third degree physical injury 53A-61, subsections A1 for an offense that occurred on 11/21/25. Mr. Bunkley was seen in court at Hartford GA 14 on 3/10/26 regarding docket number H14H-CR25-0775024-S. Mr. Bunkley received an unconditional discharge under this docket. Connecticut General Statute, disorderly conduct, 53A-182, Nolade 1/3/10/26. Connecticut General Statute, assault third degree physical injury, 53A-61, subsection A1, guilty, 3/10/26. Mr. Bunkley, according to judicial case lookup, has no pending fees or fines. BOPP may proceed with revocation hearing at this time. Mr. Bunkley's EOS date is 11/15/2030 and is on special parole supervision. Did you receive the notice of parole violation report, and the other documents I just marked for identification purposes? Attorney Dean?
Yes, we have.
The defense has filed the following exhibits, which are marked as follows. Exhibit 1, Hartford Superior Court transcript dated 3/10/26, 11 pages. Exhibit 2, list of parole accomplishments and future plans for parole reinstatement. Exhibit 3, support letter from Diane Porter. And Exhibit 4, Laz letter. Today, we have no witnesses. Attorney Dean, did you request that any witnesses be allowed to testify at this hearing?
No, thank you.
Is now the defense opportunity to call any witnesses, present evidence, and speak to any evidence submitted.
Yes, as to charge 1, I would just note the addendum is accurate. Disposition was just the 1 count of assault in the 3rd degree for which my client received an unconditional discharge, no time to serve, no additional supervision. Other charges were all nollied. I would just like to note that while we understand this conviction was entered and my client accepted this plea, it is worth, I think, noting that the complainant on record in our Exhibit 1, that transcript, indicated that my client never physically assaulted her. And the same is also indicated in the letter of support that we had submitted at Exhibit 3. Furthermore, I would just note Exhibit G, which is the warrant in this case. In paragraph 8, the officer indicates he did not observe any physical injuries to the complainant. But those are my comments concerning the charges. I would at the appropriate time like to talk about my client's background and history. Thank you.
Thank you. Excuse me. And would you like to make any comments, make a closing statement before I announce my findings?
No, thank you very much.
All right, I will notify you of my findings. On charge number 1, I find that you violate conditions of obedience to the law based on your conviction of assault 3rd degree physical injury on 3/10 when you received a sentence of unconditional discharge. In addition, I also make a finding in regards to disorderly conduct offense. Disorderly conduct offense, although it was not laid in court, I find that the behavior meets the preponderance standard based on the evidence presented by the state's exhibits A, D, and G. This concludes the fact-finding portion of this hearing. Before I make my recommendation, you will have an opportunity to speak to your background and history. The purpose of this part of the revocation hearing is to help determine what outcome I will recommend. Attorney Dean, do you wish to make a statement regarding your client's violation, background, or history at this time?
Yes, please. Thank you. My client, Mr. Bunkley, is 35 years old, born and raised in Hartford. He does have a strong support system in the community, including his grandmother, his brother, and his 3 sisters. Previously, while incarcerated, my client did sadly lose both of his parents. His grandmother does require a lot of help in the community, and he was helping take care of her. He also has a 3-year-old son who he actively helps to care for. Most recently, upon release to special parole in July of 2024, my client successfully completed Steinhouse. He then was self-sponsored at an apartment through the Chrysalis program in Hartford, and then he was sponsored by his aunt also in Hartford. He reports obtaining various certifications, including OSHA and flagging from the Best Chance program out of Hartford. Most recently, he was working full-time as a valet at St. Francis through the LAZ parking company for approximately 10 months. He was prior to that full-time at WB Mason warehouse at East Windsor. He does have extensive work experience in warehouses, including Trader Joe's, FHI, and also UPS. Most recently, he did successfully complete the Explore program in 2024. He does suffer with epilepsy, which he is able to manage through medication. My understanding is that he successfully completed his GPS monitoring while in the community. Upon reinstatement of his parole, he would like to be sponsored by his aunt, who he previously was sponsored by at the address in Hartford. Should he be placed in a halfway house, he would like the Hartford jurisdiction. He has, lived the majority of his life there and does have a strong support system in that area. He hopes to enroll in a cosmetology program for barbering and also is hoping to go and do the tractor trailer training program to get his CDLA. He does have an opportunity to work doing flagging for a company out of New Haven. I believe he had secured that position prior to his remand, but he is hoping to return there. He's very open to any sort of treatment recommended, and he's most, I think, of all excited to reunite with his son, which is, I think, the most important thing to him. I am asking that you consider a sanction not to exceed 4 months for my client. He has been out for over a year and had been doing pretty well on supervision. I don't believe has had any DRs since returning to incarceration. I also believe that he did turn himself in on the warrant for this case and did do the right thing there. Furthermore, we are requesting that I know oftentimes anytime there's a DV arrest, there's typically a request for a no contact order. We are asking that not be put in place with the individual with the initials DP. I think the evidence submitted shows that this was not a physical altercation and that both parties wish to have continued communication, especially for the sake of their child. And Mr. Bunkley, is there anything I didn't include that you would like to say at this point?
No, you pretty much said everything.
Thank you.
Anything else?
That's it. Thank you.
I've listened to testimony and reviewed all the evidence provided. A couple of notes before I announce my recommendations are, you have one previous violation while under this term of supervision, which was absconding and criminal. Additionally, you have a history of domestic violence. I did take into consideration that you were on supervision in the community for approximately 1 year and 6 months prior to this violation and no noted misconducts. Based on that, I recommend that your parole be revoked and that you serve an approximate 5-month period of confinement as a sanction with a re-parole date of May 29th, 2026. I recommend the following conditions: general no contact with DP without PO's permission, behavioral management for domestic violence. Although the parole violation report indicates this program was completed, the new violation behavior is family violence related, and therefore I will recommend this condition to be imposed. I also recommend halfway house placement. In your aunt's address is in the exhibit?
Yes.
Yes, okay. That's it. My findings and recommendations will be forwarded to the board on April 16th, 2026. You should receive the official written decision from the board within a week from that date. The board may lessen the recommended sanction, let my recommended sanction stand, or impose a sanction longer than what I have recommended. If the board decides to impose a sanction longer than what I've recommended, then a supplemental hearing will be held. Before the hearing, the board will provide you with written notice documenting the specific reasons why they might want to exceed my recommendation. During the supplemental hearing, you will have an opportunity to respond to those specific reasons while in front of the panel of the board. This concludes the revocation hearing. I am now going off the record.
So Mr. Bunkley, I'll reach out to you, or if you can get a call into my office on the 16th, we can let you know what the parole board decides. As the hearing examiner stated, they could do one of 3 things. They can accept the recommendation he made. They could give you potentially less time, or they could give you more time. But if they did ask for more time, we would get another hearing, okay?
All right.
So if you want to just follow up with us on the 16th, we can let you know what they decided when they deliberate.
All right. Thank you.
Great. Thank you very much.
All right.
You're all set, sir.
All right. Thank you.
Theo Menard, I'm trying to connect to Cheshire and they just haven't answered yet.
Okay. I'm still waiting on, to hear back from the captain at Cheshire. He was telling me the inmate was refusing to come down, so, we'll, attempt to call again and see what's going on. Thank you.
Thank you.
Regarding inmate Ryan Bailey, inmate number 342318, he has, per captain at Cheshire CI, the inmate has refused to come down for his parole revocation hearing, and it will be continued to April 27th, 2026. Thank you.